Any mention?
May it please, Lordship, I beg to mention item number 12, Lordship.
Yes.
I'm praying for 2 weeks' time, Lordship.
No objection, Your Lordship.
12, 2 weeks on the request of the petitioner. Yes.
Obliged, Lordship.
Obliged, Lordship. Your Lordship, I beg to mention item number 16, Your Lordship. The conducting counsel, Ms. N.G. Shalla, is indisposed.
Who is the other side? You are there.
Lordship.
What is the matter about?
It's a
Lordship, this
POXO
is
matter, Your
POXO
Lordship.
matter 482.
Quashing.
Lordship. Quashing.
Yes, Your Lordship. Quashing 482. After 2 weeks, Your Lordship.
This will be after 2 weeks on the request made on behalf of the state respondents. All right.
Obliged, Lordship.
Yes.
Right.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 10, Your Lordship. Lordship, it's a joint request from both the parties, Your Lordship, as the conducting counsel is on sanction leave, Your Lordship.
Appearing for the petition.
Yes, Your Lordship.
No objection.
No objection, Your Lordship.
When?
After 2 weeks, Your Lordship.
Item 10. After 2 weeks on the request made on behalf of Dr. and Mujiga, learned. DSG. Yes.
Much obliged, Your Lordship.
May it please your Lordship. Lordship, I beg to mention item number 13. It is a joint request, my lord. Conducting counsels are on their legs today and have hearing matters in other courts.
Can it be ground? We will not allow any adjournment on this ground.
Your Lordship, we already informed Your Lordship. So, you already informed your Lordship yesterday that Mr. Sun won't be able to
No,
take
no,
up the
can it be
matter.
ground? Can you make a mention saying that the council will be arguing matter with other group?
No, Your
We
Lordship.
will not allow any adjournment on that part. If you seek time, you must know what ground is, on what ground you are entitled to get time. This cannot be ground.
These are part heard matters, my lord, continuing since yesterday.
Whether it will be taken up or not, just wait. If at the time when this matter is called, if the councils are not free, then we will see. Yes.
Sure, I beg to make a mention for item 9, Your Lordship.
Yes.
Pray for 2 weeks' time, Your Lordship.
The other side?
Madam Yangi, Your Lordship, she's not
Where
around.
is she? Yes.
We pray for 2 weeks'
You are
time.
appearing on behalf of.
Yes, Your Lordship.
No objection.
No, Your Lordship.
2 weeks. The request. Yes.
Really obliged, Lordship.
Supplementary causes, item number 1.
May it please, Your Lordship. Lordship, I humbly pray if this matter may be taken up on Tuesday, Lordship, as the learned DG is on sanction leave, Your Lordship.
No objection, my lord.
Just on the request made on behalf of Mr. Dr. Anwajiga, Lawrence DSGA. This is matter. Doctor. This is matter on
Tuesday, my lord.
next Tuesday.
Yes, Your Lordship, next week.
He's out of station now.
Yes, Your
When
Lordship.
he will be back?
Your Lordship, by Monday. So if this matter may be taken up on Tuesday, Your Lordship.
Make it on Tuesday. List it in the motion column. That will be. This will be next.
Highly obliged.
Daily cause list, item number 1.
My lord, this matter, I prayed for adjourning the matter after 15 August, if your lordship permits. What happened, my lord, is a land acquisition matter. The government proposed for acquiring the land. including my land, for expansion of the highways. Now, when they do the expansion, without conducting survey, they started constructing the highways. Expansion started. We approached before this honorable court, and
The survey means without drawing up any acquisition proceeding. They took over your land.
yes. And now what they do, we asked for staying the acquisition process, but this honorable court refused to do that. But make an observation that when they go for constructing of the highway or expansion, the government respondent has to maintain the records. Now, how they need to maintain the records? They need to come for survey, measure the land, whatever trees are there, food grains are there, they will measure it, including the size of the land. The collector, they're not doing it. Now, that is the subject matter here. Now, our question is that the government proposed to acquire the land and we ready to give compensation to the landowners for a small chunk of land by claiming that 10 meters from the center line is a ROW, right of ways. And the right of way is derived from the district council order. And district council is a party, and district council say that they maintain that right of way 10 meters from the center line. It is derived from the Karo Hills Autonomous District Land Regulation 1954. And because of that, we challenge, and other Nokma council also challenge pending before division bench. And last week the London division bench just posted the matter.
Council adopted Assam London Revenue Regulation.
Yes.
And the provision made therein says the 35 feet.
35 feet. 35 lordship is recollecting. So that is subject matter before the London division bench, validity of the very act. And the matter is posted in the first or second week of 16 August. So this has a direct bearing. The division bench matter has a direct bearing in this regard to this matter. So I prayed for, if the matter is in the third week of August.
They are asking for third week. This matter is prolonged, lingering this matter, Your Lordship. Moreover, this project already has been.
Pendency is harming you.
So, Your Lordship, this matter already Deputy Commissioner has taken the decision, and after that there was only objection by the petitioners only, and most of the people they have taken.
Decision means like this. The submission of the senior council shows that this authorities are supposed to maintain record.
So, Your Lordship, on the basis of the submission of the
that is
learned
what is to
senior.
be done.
Your Lordship,
But then, one second. Your claim here is for compensation.
Yes, for compensation, including
But
the.
then you said that there was some order passed whereby the authorities were required to maintain record.
Yes, in the event of proceeding, though this Honorable Court did not stay the land acquisition process, but the event that if the authority proceeds for acquisition, authority has to maintain the records.
So have they proceeded?
In my area, not yet, but other areas, they are doing it.
So long they do not proceed, you will not have a claim for compensation. You said that there is no notice for acquisition or.
But it is there in my place also.
Proceeding has been drawn up. So once proceeding has been drawn up, they are bound to do it. I don't think you need any judicial order for maintenance of record.
Right. Therefore, earlier in other part of the land, they do the constructions without any survey. And when the landowner assert their rights, they check the records. That is the problem. Because of knowing this very well, this Honorable Court make an observation that the record should be maintained.
This is a national highway.
It is a national highway.
Then in such a case, that stipulation of 35 feet, that may be provided in that national highways.
My lord, it is not there with regard to this area.
Your Lordship, this.
And that is not the case of the response.
This is the 7/8 of 2020, the order referred by my senior stewardship. In MCWPC number 125 of 2020, when this petitioner first approached before this court, that point when stay was rejected, then passed the order, then it was given in the last paragraph of this order.
This court could not get what you are trying to say.
Your Lordship, the submission made by the senior counsel, this is the MCWPC number 125 of 2020 in this case. The order was passed, and in this case, stay was not granted and given some direction to maintain.
That is why the submission has been made by this.
So, Your Lordship here, and subsequently, Your Lordship, I approached before this court. This, then after this court has given the order, to go ahead their way and they'll not be objecting, but they are objecting now. So in the event of they are only entitled for this compensation in concern, so it will be divided by the deputy commissioner. And already NHDS has made payment to the
Who are you?
deputy
The land has been acquired at
for
no
the
behest of
project works of this highway.
central
And
government is a
then it is given.
He's
It is for the.
implementing it
It
in
is for the
NHITCL.
NHDCL. I am for
who is
the.
paying for the state here? Why you are staying behind? Standing behind.
So,
The union is the requiring body here.
Yes, they are the
They are
required.
the requiring body.
But then acquisition proceeding, once it is done, that becomes your business.
No, I understand that.
That is not for them to basically see that the.
No, while implementing the work, they were facing some troubles with the petitioners.
No, but then implementation is your work.
No, that is also true. What I'm saying is, at the moment, what the petitioners are asking for is some accommodation because.
But that
there's
is
a
all
matter
right. That we
pending for the
understand. That we understand. That we understand. That this court.
but if it is coming in
But then
August, then it will be.
say supposing you see like if it is not a direct claim for compensation, say like that here submission has been made that till now their land has yet to be taken over.
So
It
in
is
such.
remaining with them. It is not a case that you have taken over the land, you have not paid them.
Gotcha.
Now, if that be the situation, definitely there is a scope that you will be paying them
Gotcha.
once you take over the land.
Correct.
So why should we entertain this? Keep this petition pending.
There
When the
was, in fact, a
situation comes,
number
they
of
will come and
petitioners.
approach.
If your lordships recall, they filed an application on the last occasion for dropping certain names.
Yes.
So we'll have to check how many names are still pending. How many of the petitioners have not yet been paid?
Oh yes, some application was filed that this they are negotiating with the government or something like that.
That was struck out
But
by
if there is
by
till
this court.
now, if there is no cause of action, then why should we keep this pending? Better pending. You will have the liberty to approach the court if you find that a compensation has not been paid. It is irrespective of what decision has been taken by the division bench.
Minority cause of action still survive. Other occasion, a few of the
Your land has not
landowners
been- your land has not been taken over till now.
they
So
receive.
it is an anticipated cause of action. Can it be maintainable on anticipated cause of action?
No, minority notification has been issued. They have invoked the land acquisition.
They have not
Acquisition
taken
Act.
over your land, isn't it?
They have notified my land, and larger chunk of my land is omitted.
When it was notified?
Minority we have filed
There is a provision of
They are claiming
2009,
title over the 35 feet.
2020.
They're claiming title over the 35 feet.
That right
because
of way,
the 35
whatever
feet
you
is
say, right
prohibited
of way.
before this court.
Right.
So that is the issue of title. That will be
This
decided. by
right
the
of
special-
way, it comes of from which what provision of law? Is
From
it only
what
for
we
the
understand
land?
from the Assam Land and Revenue Regulation,
That is the only provision.
which has been
There
adopted
is
by
no
the
provision
GHG.
made out in the National Highways Act or the that certain part of the portion of land should be.
So for other states, there is. They still call it the ROW, right of way.
This National Highways Act is not applicable here.
Some they have some notifications that they've given us. They're also not very clear.
Please,
that
please
the center
verify
will have
those.
to
Please,
assist
please verify those parts.
Gotcha.
See,
Though-
it is. You see, like for National Highway, there is a probably regulation which said that certain
We have
portion of land
right.
should
Yes,
be left there.
right.
It may not apply to state roads.
Gotcha.
Okay, so that is what. That Assam land regulation, provision of land revenue regulation may apply for the state roads which are situated. But then that other provision, this is for the construction of national highway, isn't it?
National highway.
Then
Lordship,
that
we have
land
seen.
revenue regulation might not be the only regulating. You see, like the regulating law.
Right.
You see, like.
Right. Lordship, there is in the National Congress, the government is with regard to national highways. We have seen, we have checked. Now the government acquired 10 feet. Now government utilized only 6 feet. Remaining 4 feet are there. These 4 feet are considered as ROW.
How this court
Now-
will go and determine all those things?
Since we are talking about the ROW is not, my lord, where the land was never acquired and government suddenly claimed ROW. That is not the case. ROW is government acquired already long ago, partly not utilized, and they will go for the expansion, and they will claim that only is ROW. 30 years ago, I have acquired 10 feet. I utilized only 6 feet. Remaining 4 feet are ROW. They can do that. Here is not the case. Existing is only 3.5 meters. Existing roads. Now suddenly they claim 10
It
meters.
is admitted that existing road is 3.5 meters.
Yes, survey.
What basis you say?
That's their own survey say. Survey say.
The survey. So there is a
Their own
report.
survey say. Yes.
So there is existing road of 3.5
Yes.
meter.
Yes. So more than 6 feet, 6 meters are mine, are owned by the petitioners.
And then can
certainly
be,
they claim
it
that.
could go enter into that controversy and determine.
My lord, therefore, at this stage, my lord,
we'll
we
just
kindly
I would
issue.
say Lordships can have it tomorrow and satisfy my lords on the question of title. Writ is not maintainable, even in an LA proceeding.
They cannot do that.
It would have to come in the purview of the special law.
That is what this court also thinks.
That my lord, well, there is no one who claimed the title over my
No,
name.
they are asserting
You
title.
know,
over that area.
government is not claiming the title. Collector is in his affidavit, they are not claiming title. District council is not claiming title.
No, but then what is your cause of action here?
Therefore, larger chunk of my land is omitted in the notification. Therefore, we are challenging the notification.
So essentially, my lords, some area has been omitted.
That is
They
right.
claim they have title over that area. So it is a title dispute.
You see, that be the thing, then again it comes to a this thing claim of title over there.
Lordship.
You're claiming ownership over there. So that is title.
My
It is not required that they also should claim title. It's
none
your
of them are
claim was
claiming
enough.
title.
You see, that is
None of them
what
are
you see,
claiming
this
title.
court has reservation. Just think over. We'll adjourn it for the timing.
Yes.
And we'll just see. But then,
Your Lordship, because of this,
unless there is a cause of action,
We'll satisfy cause of action.
Writ will not be maintainable in a situation like that.
Mr. Devnath also is not much here now. Now it will be your role too, basically.
Lordship.
so Your Lordship, our rule is here at the moment because Your Lordship, we have the execution agency there to execute the work. So if you are not getting, and then state is going to be affected, and our fund is blocked, unnecessary. And it is for the public interest. And it is not the individual, it is the public interest.
There
And
is
it
no
is
restraint.
either come up, it is
They can
for the
proceed for
state
acquisition.
as a whole.
Question here involved is only the payment of compensation. So that is what
So,
collector will
so,
take care. It is not for
so Your Lordship, here our constitution is there. Let us go ahead the project. Even earlier one order also there, and this was given that direction to help us. So in such situation, it will come up if we go for the project work in here, and then if the petitioners actually they are entitled for any sorts of compensation, so we are not denying this. We will not get the compensation.
After destroying the entire land, my lord, how the petitioner will claim the benefits? Therefore, this Honorable Court made it very clear.
Already it is verified.
In the event of proceeding the acquisition, you maintain the records.
Your
They
Lordship,
don't want to
already it
maintain
is.
the records. They don't want to come for survey.
if there is an order to maintain the record, they are bound to do.
They are bound to do it. They
You
can
do not, have
proceed.
to do not have to follow it up. Whether they are doing it or not, they
Right.
do not have to report it to you.
Exactly.
If you find that has not been done, file it on time.
Exactly.
If you find that you have suffered because of non-maintenance of record by them,
Right.
then definitely when that situation comes, you will have your cause of action. But then right now that situation has not come.
Not that.
Anyway, we'll just say wait for the outcome of that division bench matter. But then why to wait for that long if
My lord,
we can dispose it on other
it
ground?
has a direct bearing. That lordship has pointed out 10 meters. That is the issue here. The moment, my lord, in the event if we succeed, Nokma Council and the petitioner succeed there, the ROW will go.
But may I just
They-
point
they-
out what is the actual
ROW
nexus
will go.
under the Garo Hills rules, which has been adopted, which has adopted the Assam Land and Revenue Regulation. The district council issues pattas. In that patta, there is a stipulation that 25 feet from the center of the highway,
35 feet.
35 feet, they will
35.
not stake any claim. That is why they're challenging.
See, the
the
stipulation made in the pattas is
Lordship.
that in case of construction of any government road and all those things,
Lordship.
they are liable to vacate
Lordship.
that area.
Lordship.
That means, meaning thereby that the 35 feet land should not be occupied.
Should not be occupied. Exactly.
That it should be left unoccupied.
Lordship.
That is what.
Right. And if government require, they can acquire it.
Now
That is the
Here
that
the
is the
solution
limit.
is that
JTCC's power.
whether that regulation will be applicable or not, that is being challenged.
Yes.
The very adoption of that by the district council has been
Right.
challenged by the Nakmas there.
Yeah, Nokmas and the petitioner
So
here.
once if they say if they are successful, Nakmas are successful, then they may not have to leave that 35 feet.
Right.
That rule will not be applicable.
Lordship.
And in such a case, you will be liable to pay them. That is what.
If that event arises.
That is.
Lordship.
That event may not arise.
May not arise.
Let's see.
Okay, just London Senior Council appealing for the parties. Appeal for the petitioner submits that this matter is dependent on the outcome of. What is that case number? Do you have?
My lord, we will supply the case number.
Supply
Two case
them-
numbers are there.
Supply the case number.
Yes.
Will depend on
My
the
colleague will supply
outcome
case
of the
number.
such and such pending before
Yes.
the division bench to some extent. We are not saying fully dependent to some
Oh,
extent.
yes.
Or shall we say fully dependent?
Is it dependent? According to me, it is a
Totally dependent.
is a dependent on this.
Entirely dependent, my lord.
Whatever decision is made there will result in closure of this case also. Do you want to say that?
May be a little prejudicial. May have some bearing.
No.
That is
We have
That is what-
he
then we are
has a
saying
direct
that it will
bearing.
have dependent to some extent. That is what. What we said? And Senior Counsel for it.
Two cases are there.
This is such and such case number pending before the to some extent.
Yes.
And the matter pending before the division bench is likely to be taken up
My
for
lord,
hearing
on 16 August.
on
So if it is 16 August, it will be long pending, Your Lordship.
16th August 2024. It is therefore prayed by the petitioner that this present matter may be taken up after the matter pending before the division bench is disposed of, decided and disposed of. Yes, what do you say?
So, Your Lordship, if
No,
it is coming,
what you want to say with regard to the prayer for adjournment?
my objection was there in Lordship in this way, that division-based matter is completely different one they are giving this
Okay,
one.
so you have to dispute it. So you should have said it.
So, Your Lordship,
Your
Your Lordship, already acquisition position took place. So, if division was taken the matters, another matter, some notifications come up and going to be come up. So, it is not related to this
No,
matter.
but then Mr. Shen said that yes, it will be to some extent it will be dependent on this.
Your Lordship, to the extent of if it is come up the other ownership.
Anyway, just say the submission of the learned senior counsel has not been disputed by Mr. Shen, learned senior GA. Are you still a senior?
GA.
The only case of demotion. Yes. Learned GA. Give a comma, however, he submits that matter may not be totally dependent. However, he submits that the matter pending before the division bench may have some bearing, but it cannot be said that this present proceeding will be totally covered by the outcome of the decision of the matter pending before the division bench. Stop. Mr. R. Devnath, learned CGC, disputes the submission made by the learned senior counsel for the petitioner and submits that this present matter has no connection whatsoever with the matter pending before the division bench. Correct?
As because all land acquisition proceeding taken already in this matter. Land acquisition matters already taken.
No, see, we are not going to see. Land acquisition proceeding is taken to see which way it has. The question is the application of the Assam Land Regulation. So that is the applicability of the Assam Land Regulation.
So in this case also, Your Lordship,
We have recorded your submission, but then will not go by your submission. Okay, since you have made an objection, so we are recording it. But then since the state is not totally disputing it, so in view of contradictory stand of the respondents, we are not going to reject the prayer made by the senior. So we will allow it.
Well, may I just also clarify that while they say that there is some nexus with the proceeding before the division bench, this writ petition can be disposed of.
No.
Even without awaiting the outcome of that case. That is my submission.
So then in such a case, we will have to disallow this prayer for adjournment. Then
I'll satisfy my lords that there's no
then
requirement
we will
to wait
proceed
for
with
that.
hearing. You see, this entire thing is futile.
It becomes a little complicated as well.
See, Mr. Sanglesho, if that submission is disputed,
All throughout, the state also did not dispute.
that is okay. I have
not
seen the
dispute.
previous orders.
Yes,
I
yes,
have
they are
seen
not
the previous
disputing.
orders.
Suddenly they are disputing this.
No,
That
I'm
is not
saying
correct.
my lord, what I'm saying
That is that is
now
improper.
that several people have been dropped from the area of parties, and the question is on the issue of title. I'll satisfy the
No,
member
no,
that issue of title cannot stop the DC from proceeding with the matter.
No,
That's
now
the
Earlier
right
they
now what we
admitted.
are concerned is with whether the matter before the division bench will have some bearing in this.
So even if, let's say that the legislation is set aside and declared as ultra-vires, they can take that plea before the DC, before the collector. It's not
No,
necessary they have to take that plea.
Notification, the notification we challenge will be strike down.
No, no. That
If the division
that will not
bench
affect
accept
this
my
case.
prayer. Exactly.
That will not affect this case.
This will affect.
Lordships can have it next week. I'll
They cannot
satisfy the
dispute this.
lordships.
In the last number of occasions, we informed this court, and they also conceded that
Your
yes,
Lordship,
it has a
that point
bearing.
of time, whatsoever the
It has a bearing.
submission.
We just cancel this entire order. We'll have it next week, Mr. We'll have it. Let us see. Because otherwise, it will not keep this matter pending unnecessary. Yes, London Senior Counsel applying for the petitioner submits that the matter pending before the division bench having bearing on the outcome of this present matter is yet to be disposed of and prays that the matter may be adjourned till the outcome of till the disposal of the connected matter pending before the division bench. The submissions made by the London Civil Council, however, stands refuted both by Mr. Shen, London GA, and Mr. R. Devnath, London CGC, appearing for the respondent number 15 and 16. Yeah, 15 and 16, isn't it?
16. 16.
According to the London councils, that this present matter can be disposed of independently on its own merit, without waiting for the outcome of the matter pending before the division bench. In view of the submissions made, let this matter be taken up for hearing. When? Next week?
Thursday or Friday.
Anytime. I'll satisfy.
After a week we'll do.
Yes, Lord.
What we said, invitation submission. List this matter after a week for hearing. It is otherwise in the order in the hearing column.
Admission hearing.
Also, then do not list this matter after a week only. Just say. Do not say for hearing, otherwise there will shift all this. So it will come up in the admission thing, and then we'll just see. Yes.
Item number 2.
I'm praying this matter may come at the end of the board, Lordship.
Why at the end of the board?
Senior counsel is unlike Lordship. Senior counsel is unlike Lordship.
You are there. You are good.
Lordship.
Yes, what for it has come up?
For orders, Lordship.
Yes.
End of the board. Bless, Lordship.
The end of the board.
Item number 3.
Yes.
Lordship, order dated 15/5, my lord. We have taken steps upon respondent number 2, your lordship. On 17th May, we have
Yes.
taken steps,
Not.
your lordship.
Yes. So,
So
what
now,
is your prayer now?
your lordship,
But there are certain facts which require to be brought on record, so I'll require to file an affidavit.
So, you will file a response to the.
Yes, the response.
Yes. Okay.
my lord. My lord.
Mr. P. Nombre, Learned Counsel, enters appearance on behalf of the respondent number 2 and submits that a response is required to be filed by the said respondent for bringing it into a response to the petition filed by the petitioner is required to be filed by the said respondent to bring on record certain documents and facts which may be necessary for proper adjudication of the matter. The Learned Counsel prays for grant of some time for filing a response. What about you?
The state, your lordship, we've taken instructions, your lordship. The investigation is going on as for now, your lordship.
That is the only instruction.
Yes, your lordship.
And
Verbal instruction.
And
that
then
we've
what
received.
what about your instruction so far as the prayer made in the petition is concerned?
Your lordship, my apologies. This matter is being conducted by Mr. N.D. Shulai.
The first part
He's
of
on
submission
legs
was
now,
all right.
your
Second
lordship.
part.
I
You
was
should stand up
informed
with all these
of the
things. Whether we'll
objections.
have any objection or not objection, that is at least what is to be. At least
He's
you
on
can
legs,
disclose
that's
that.
for now, your lordship.
Anyway, just in view of the submission made, list this matter after. You'll come after 2 weeks, Mr.
My lord. Interim order may kindly be continued. my
Okay. If there's an interim order.
lord. Yes, your lordship.
Okay. The interim order stop. The interim order. First order. Let it continue until further order. Shall continue until further order. Yes.
Obliged,
Mr.
lordship.
Deeply,
Mr.
Hearing item number 5.
deeply applied.
Should be the last one. Lords, by the order dated 7/5/2024, Lords had directed the state to obtain certain instructions. This is the matter regarding those two schools with the same name, Lords.
Order dated
7/5/2024, Lords.
what is the instructions? 9-4.
My lord, on the last occasion, my lord, I had obtained instruction regarding the bank account in which the money was deposited to the school managing committee. And my lord also had seen as part in the part hearing. My
Is
lord.
it? Now, if you say something has been seen by the court, it is very difficult until unless it has been recorded in the court.
No, my
Court
lord,
order
I
that it was
obtained
produced
certain
and was inspected by the court. Otherwise, the problem is these matters are hard and adjourned, and then it becomes very difficult for the court to remember. Well, Mr. Paul, can you just give the background on that?
Well, this is a matter where the petitioner was appointed in a certain school, Millets. Give me the writ petition. This is called as the Rajbari Girls, Rajpur Girls UP School, Millets. And I had taken your lordships to Annexure 1, page 20. If your lordships kindly have a look at Annexure 1, page 20, Millets.
Yes.
Well, it's at serial number 3, if your lordships kindly see, is the name of the petitioner. She was part of the managing committee. Well, it's-
Yes.
Now, what had happened, Millets, is without taking your lordships through the papers, Millets, I'll just give a brief backdrop. There was some dispute between the managing committee and the teachers, Millets, because the salary was withdrawn from the by the managing committee but not disbursed to the teachers. So, Millets, what we had pointed out that there was a resolution taken to shift the school from place A to place B. The school remains the same, Millets, but only it was decided, the managing committee had decided to shift it. There was
The
approval.
school building was shifted.
Millets. School building was shifted from place A to place B. Subsequently, Millets, what happened is.
When it happened, the shifting of building?
Millets, that. Where is that resolution? Millets, it is dated the 20th of April 2004.
By a decision of the managing committee.
Managing committee, Millets. That your lordships would find it Annexure 5.
Just a minute. 1 minute. What is the date of shifting, you say?
Millets, the resolution is dated the 20th of April 2004.
Yes, and at page, there is that page?
Millets, at page 32. Annexure 5, page 32. Now, it's the typed copy your lordships would find at page 30.
Page 30.
If your lordships have it, Millets, I can just read it for you. Millets have it.
Yes.
This is resolution number 1, Millets, at Annexure 5, page 30, if your lordships have it. As against the first agenda, the meeting discussed threadbare the need of shifting Rajpur Girls Upper Primary School from the present site near Rajpur LP School to some other suitable place due to the recent clash between the existing teachers and the secretary of the school, Shri Mukhtar Hussain, and his men over the disbursement of salary, etc., leading to police case on the basis of the verbal order of the DIO of schools, Dadangiri, and resolved unanimously that the said school, Rajpur Girls Upper Primary School, be shifted to the plot of land owned by Shadibor Rahman of Rajpur village, bearing patta number so near Gram Sevak quarter, Rajpur, to avoid similar clash and disturbances to the peaceful and smooth conduct of classes of the school in future. Well, it's down below your lordships will see approval was given by the Deputy Inspector of Schools on 20th.
But then who has taken this decision?
Well, it's
it seems you were.
Annexure 5, well, it's the original is at page 32. Your lordships will see the entire managing committee is there.
12 members are there. No, it is more than that. Just see.
My lords.
So how come?
The managing committee, my lords, other members of the general public were all present over there. Suleiman Haq.
Proceeding of the general meeting. See the next thing.
My lords.
What do you mean proceeding of general meeting of whom? This is not a meeting of the managing committee. You cannot say this is a meeting of the managing committee.
My lords, the members of the managing committee are all here, my lords. That's what I'm trying to say.
See, there are, how many signatories are there?
Total, my lords, 58.
So, we have only hardly 11 members.
11 members, my lords. In addition to that, there were other people. In addition, what I'm submitting is, my lords, in addition to that.
There cannot be other people in the meeting of the managing committee. Cannot be. Once moment there is other people, then cannot be meeting for a managing committee.
My lords, may not be per se of the managing committee, because if your lordships go back, it says proceedings of the general meeting held on so-and-so in the house premises of local headman and GB governing body at Rajpur village. That's what it says.
Of Rajpur village, not of the school. Now, if there is governing body of Rajpur village,
there is nothing called.
Anyway, it's okay. No problem. You have referred it. Carry on with submission.
So this decision was taken, my lords. That was approved by the DI of schools on 23/4/2004, my lords.
What is the approval at?
Your Lordship would find that approval at page 36.
It's approval on the body of the resolution only,
Itself, my lords.
not by passing any order.
No separate order was passed.
Approved on same day? Is it approved on the same day?
Yes, no, after 3 days, my lords.
On
Because if your Lordship's resolution number 2 would also be relevant for this purposes, if I may just quickly read it.
Yes, yes.
Resolved that the president of the school be authorized to submit the proceedings of this meeting to the DI of schools Dadangiri, as the secretary, having involved himself in an undesirable clash with the school teachers, recently has remained absent from this meeting. The meeting ended with a vote of thanks from the chair. So the president placed these minute smellers before the DI and the approval was granted.
Yes.
Now, subsequently, my lords, there was various rounds of litigation where there were directions issued by this honorable court to inquire and find out as to, my lords, who had misappropriated the amount of money which was due to the teachers, and that was the position, my lords. So ultimately, my lords, in the defense that has come before this honorable court, what now the state and the respondents are trying to say is that there are two schools of the same name. One they say is the original school, and one they say is the, if I may use the expression, my lord, what they say is a fake school run by the petitioner. That's what they say. Now, after hearing us at length, my lords, the query that had fallen from your lordships was that the petitioner was very much part of the managing committee of the original school. Whether the school has shifted or whether it has not shifted, there would have to be some documentation to show that a petitioner was removed from the post of my lords, from the managing committee of the school. That is number one. Number two, the money which is being paid by the government would necessarily have to go to the managing committee of the school in an account maintained by that school. Merely because the building of the school has shifted from place A to place B does not mean that there would be a second account. So naturally the money would have gone from the government, it would have gone there. So that would establish, my lords, which is the proper school and from where the money is going and how it is being utilized. To that extent, my learned friend was required to seek instructions and place it before your lordship.
Yes. Please, this occasion, once you please produce the copy again. What happened in the last occasion, this court has forgotten. Kindly.
My lord, what we brought forward was the copy of the passbook, my lord.
Just
copy of the passbook and bearing account number 01100.
Any affidavit filed by the state. What is your contention in the writ petition? What?
My lords, what we say is that I'll take your lordships to the last orders passed by this honorable court, my lords, on the last round of litigation.
What are the grounds you have raised, the main grounds raised in the writ petition?
My lords.
Because state will have to reply to your contention.
My lords, they have filed various affidavits. What had happened is, my lords, there was an inquiry that was directed by this honorable court on an earlier occasion. They conducted the inquiry, my lords, and they directed an FIR to be filed against the then secretary of the school for misappropriation of that amount of 78,000.
Just come to your prayer at page 7.
My lords. Under the facts and circumstances, therefore, your lordships would be graciously pleased to admit this petition, call for the records and rule issue upon the respondent show cause as to why writ of certiorari not issue, directing the respondent authorities to recover the salaries of the teaching and non-teaching staff of the petitioner's school for the period March 2002 to February 2003 from the then managing committee of the school, and further directing the respondent authorities to release the current salaries, area salaries and other benefits in favor of the petitioner's school, namely so-and-so, and stop the benefits given to the false school in the same name. Because there seems to be some serious anomaly over here, my lords.
If there is a false school,
my lords,
then who is representing that false school?
My lords, I say that the school by the secretary, which continued in that same place even after that resolution, is the false school.
Are they party here?
Yes, my lords.
They've been made a party in the
Yes,
capacity
yes.
of in the capacity of.
My lords, that particular school, the managing committee of that particular school.
If you say that you are the managing committee,
I was then the managing committee. My lords, of course, I cannot be. It cannot be for perpetuity. It's for a period of 3 years.
How many private respondents are there? Okay. Then
My lords, 1, 2, 3, 4, 5, 6, 6 private respondents.
there is managing committee is not a party here.
Well, it's because as on today there is no managing committee. That's the position that has come out, my lords.
They are all made
My lords. And they filed an affidavit
parties by
also.
name.
My lords. They filed an affidavit also.
They are all the ex-member in 2004, Your Lordship.
So then what happens now after that term of that managing committee is over? What would be the locus standi of these people?
My lords, because that money is yet to be recovered from them only, my lords. That is the finding of the...
Then it becomes a personal claiming is them now.
I'm sorry, my lords.
It becomes a personal claiming is them now.
It's not a personal claim, my lords. Because your lordships had directed in the last round of litigation, there were specific directions issued by the Honorable Court.
What is the direction?
My lords, I'll take your lordships to the directions. My lords, page 49.
How it could will give a direction to a person who is not a part of the managing committee.
My lords, the direction was to the Deputy
And then,
Inspector
in
of
fact,
Schools.
managing committee is not a part of party here. They are,
My lords, the managing committee did not misappropriate that amount.
Your claim is from individual, private individual.
My lords, at that point of time, he was the secretary. What he did is, my lords, what comes out in the finding is,
petition, he has been made party in his individual capacity.
he's no more, my lords. That gentleman is no more. He passed away.
No, then this who are these respondents? If
My
you
lords,
have a
they were the
claim-
other members of the managing committee at that point of
If you
time.
have a claim, then you have a claim from those person, individuals. Read court will not pass any direction.
No, my lords, I will take your lordships to page 6, page 49, annex 6, paragraph 6.
This is what? What is this?
My lords, this is actually the 5th round of litigation before this Honorable Court, my lords.
Page 46.
My lords, page 49, if your
49
lordships
of
can.
the-
Paragraph 6.
What is this? This is your.
This is the judgment and order, my lords, passed by this Honorable Court. This is dated, this is the type copy, this is judgment and order dated 24/9/2013.
No, but then it seems it's a part of communication.
No, my lords.
Come to page 47.
This is, my lords, it's copied. It starts from, my lords, it starts from page 43.
Start from page 43.
My lords. This is a type copy.
Okay. Yes, please.
The operative portion is at page 49, my lords, paragraph 6.
Yes, one of you can go. One of you, there's a problem. Yes.
My lords, it says, in the circumstances, this court has no alternative to direct the respondent number 4, that is the Deputy Commissioner cum Chairman of the scheme for Garo Hills District Tura, to conduct an inquiry to find out who had misappropriated the said amount of rupees 78,000 in the said letter of the Deputy Inspector of Schools, Dadangiri, West Garo Hills, dated so-and-so, and the respondent number 4, Deputy Commissioner cum Chairman of SSA scheme for Garo Hills District Tura, shall file the complaint criminal case against those culprits with the OC West Garo Hills within a period of 3 months from the date of a receipt of a certified copy of the judgment and order. The OC concerned is further directed to register an FIR on the receipt of the complaint from the Deputy Commissioner cum Chairman so-and-so, and to arrest the culprit without delay. The compliance report should be submitted to so-and-so Deputy Commissioner cum Chairman West Garo and to registry of this court. With the said observations and directions, writ petition is disposed. However, liberty is granted to the petitioners to approach this court again if they are agreed by the order of the respondents. Now, if your lordships come back to the order of the respondents, well, pursuant to this inquiry was conducted. Annexure 8, my lords. This is the inquiry dated 17/12/2013.
Page?
Page 57, my lords.
Yes.
My lords have it. In pursuance of the High Court order number so-and-so dated so-and-so, in the case of Falidov Biswas and others versus Government of Meghalaya and others, the Honorable High Court, while going into the intricacies of the case, directed respondent number 4, that is Deputy Commissioner of West Garo Hills cum Chairman SSA West Garo Hills Unit, to conduct an inquiry and ascertain the case at issue of misappropriation of 78,000, which is the allegation made by the petitioners whose names are hereunder. My lords, the name of the petitioner before your lordships, that's serial number 1. The respondents in the case are so-and-so. As per the instruction,
There are 4 names, isn't it?
my lords.
You are one of them.
One of them.
What
I am
about the
Faluda
others?
Biswas, my lords.
What about the others?
My lords, in due course, they have given up.
So it means in that 78,000, this other three also have their scheme.
Have the share. As per the instructions of the Honorable High Court, the inquiry the inquiry to examine the misappropriation of 78,000 and filing of the complaints criminal case against the culprits was to be done within a period of 3 months on the date of receipt of a certified copy of the judgmental order. It was further ordered by the High Court that the officer in charge of the police station concerned shall register an FIR on the receipt of the complaint by the Deputy Commissioner. In urgent and total compliance of the orders of the Honorable High Court in the aforementioned case, the undersigned directed all 4 petitioners, namely so-and-so, 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 Deputy Inspector of Schools, Dadangiri, President, Managing Committee, Rajpur Girls, Secretary, Managing Committee, Rajpur Girls, Shri S.D. Sangma, DSEO, Sangara R. Marak, the then Deputy Inspector and School and Joint so-and-so, Sri Gunira B. Marak, SEO, Salsala, Manoj Kumar Datta, SIC and so-and-so, Shri Solomon Haq, in the case to come to my office chamber with all relevant materials to be placed on record for the inquiry by WT message number so-and-so. All the concerned parties was to appear before the Deputy Commissioner so-and-so. The petitioners and the respondents in the case duly turned up and submitted relevant documents as well as depositions of the petitioners in the status of the case. Copies of the depositions made by the petitioners may be enclosed as so-and-so, and the depositions made by the respondents may be seen enclosed as Annexure 6 to Annexure 15. To conduct a detailed spot inquiry and to ascertain the veracity of the verify the facts on the ground level, the undersigned passed an order dated so-and-so in which Subdivisional Officer Dadangiri, she so-and-so, was directed to cause a detailed and comprehensive inquiry into the matter and submit findings to the undersigned. Upon close perusal of all the records and documents and further upon scrutiny of the inquiry report of so-and-so, the deposition of the following findings are pertinent. A brief summary of the case is followed. The complainants Faluda Biswas, so-and-so, so-and-so, so-and-so were working as teachers in Rajpur Girls School during so-and-so. When the government of Meghalaya took over the school under the SSA scheme, the SMC of the school was constituted by memo number so-and-so by the then Deputy Commissioner. Funds amounting to 78,000 were released under SSA towards the payment of salaries. But the complainants alleged that they didn't receive the salary. Subsequently, the then Inspector of Schools Dadangiri conducted a spot inquiry and found the salary was not paid to the genuine teachers. He therefore directed the then Secretary SMC to pay the salaries immediately to the complainants till none of the complainants have gotten their salaries for that period, even after the directions of the Honorable High Court. That as per High Court Order Para 6, the scope of the inquiry was ascertained. It had directed to conduct an inquiry who had misappropriated the said amount of 78,000. From the orders, the inquiry identified some key issues. They are whether the complainants, Faluda Viswas and others, had actually worked during the said period or not, whether the funds were disbursed or not, who actually misappropriated the said amount. After detailed public inquiry in which opinions and depositions were taken from the members of the SMC and the general public, it was found beyond doubt that the complainants actually worked during the said period. It was further found that the amount of 78,000 had actually been disbursed and was not received by the complainants. All the relevant records concerning this have been enclosed with the spot inquiry. The spot inquiry conducted by the Deputy Inspector of Schools so-and-so has also given the same findings. All the complainants along with the President of so-and-so alleged that the amount was misappropriated by the Secretary Maktul Hussain. As he had already been expired, this inquiry could not get any statement on defense on behalf of him. After going through the relevant documents and the conducting public inquiry in the school premises, it is found that the said amount of so-and-so was withdrawn with the joint signatures of both the President and the Secretary SMC. Both the Presidents and Secretary are jointly responsible for disbursing the money to eligible persons. But the established procedure was that the Secretary used to disburse the money after withdrawal from the account in his capacity of operating head of SMC. Hence, this inquiry feels that the then Secretary of the SMC was responsible for misappropriation of the said amount. However, with the demise of the Secretary of the School Managing Committee, the question arises about the recovery of the said misappropriated amount. The depositions and submissions made by the petitioners do not apportion blame on the then President of the Managing Committee. However, it is unclear whether the President of so-and-so took action upon receiving the complaints or not, and whether there was any lapse on his part. The directions of the Honorable High Court were to ascertain the culprits, which has clearly been found to be the Secretary of the School Managing Committee, who was dealing with the cash and was directly responsible for disbursement. On this, my lords, an FIR was lodged against, in terms of the directions passed by the Honorable Court, my lords, an FIR was lodged against the Managing Committee.
It was lodged against the Managing Committee or that particular individual?
My lords, it is against the, I'm sorry, my lords, it is against that Maktul Hussain, but he was no more, my lords. So, what transpired is that there was
so
some...
far as this report is concerned,
my lords,
that has not been disputed by anyone. That stands.
it's in my favor, my lords, so
Now,
it does
if
not...
we accept that whatever is said in the report,
My lords,
then responsibility lies only with the person who is already deceased.
my lords, it would be a joint liability of all the members of the
But the
SMC.
report says, specifically said it cannot be, blame cannot be apportioned. That is what has been held here.
It says blame cannot be apportioned to the President.
President and secretary. So no other. See, if you see paragraph 5, that makes it clear. If you see these things, so far as the withdrawal and dispersal, it seems 3 persons are responsible: President SMC and Secretary SMC. Or Joint Secretary is President SMC.
Knowledge.
Both the President and Secretary are jointly responsible for dispersing the money to himself, but the established procedure was that Secretary of SMC used to disperse his money after withdrawal from the so-and-so in his capacity had. Hence, this inquiry feels that the Secretary of the SMC was responsible for the misappropriation of the amount. So that responsibility lies with him only. So if you have to recover that amount, you have to adopt some other measure, not by this.
No, man. Mallods, I'll draw your lordship's attention why I say the managing committee, Mallods, page 62.
Page 62.
Mallods, this is the FIR.
Yes.
In pursuance of the order number so-and-so dated 17 December passed by so-and-so Deputy Commissioner Tura in connection with the misappropriation of money of so-and-so, Mallods, the names, the order directing the OC Fulbari PS for registering a case. During preliminary inquiry, it is found that the prima facie accused who is involved in misappropriation of the salary of the then managing secretary of Rajpur so-and-so Maktal Hussain has expired. However, the school managing committee is also liable for the same, including the president of the SMC. A regular case under appropriate section of law may kindly be registered against the president and members of the SMT to find out the other co-accused involved in the scam and to deliver justice to the victims. So, case was registered against the entire SMT.
Okay, there is an allegation, but then it seems that whatever is stated in this FIR is in contradiction with the inquiry.
Well, this FIR is filed by them.
It is not a conclusive piece of evidence.
I'm sorry, Mallods.
FIR is not a conclusive piece of evidence.
Mallods, what I'm submitting before your lordships is based on the inquiry of the deputy commissioner. This FIR was lodged because it was the deputy commissioner who directed was directed to lodge an FIR for investigation. So I am nowhere involved in it. It is the state machine.
This investigation?
Well, only the state will be in a better position to.
What happened to the investigation, Mr. Sangupta, of this case? Page 62. Let us see whether this criminal case has fixed responsibility to somebody or not.
No.
How do you know? You are saying no means like that statement will go as no.
My lord, in the final affidavit which was filed by the...
Anyway. Please find it out. We do not know. Yes, Mr. Paul, you carry
Well,
on. Then what happens?
Just bear with me for a second.
So, no, see, you do not know what is the outcome of this.
We don't.
Why? Was it not required upon you to pursue and see what happened?
Well, we went, recorded our statements. After that, we will be called by the investigating officer. We have not been called. Then, Mallods, I wrote several representations to the respondents for release of the salaries, the current salaries. Now, all that, Mallods, nothing was paid heed to. That is why I am before your lordship.
Established who is responsible for payment.
Well, that is only with regard to...
At least then in such a case, you are not blaming the government because money was released.
Government has released the money.
Committee and the individuals who are the part of management.
Mallods, what has happened thereafter is, now very interestingly in the affidavits which have come before your lordships, the government also says that there are two schools. Which after hearing us at length, my lords had said...
But then your salary is only confined, the claim in the writ petition is only confined to the payment of salary for that year.
No, my lords, there are two aspects. One is that 78,000 from 2002 to 2003 and the current salaries. Current salaries, area salaries, that your lordships have seen, my lords, in my prayer. Now the government is saying, more importantly, my lords, they're trying to say that there are two schools. Now what had fallen from your lordships is, how can there be two schools on the same name?
Definitely, there cannot be two recoveries.
There cannot be, Mallods. And number one, Mallods, what had fallen from your lordships is that the petitioner was very much part of the school and she was also part of the managing committee. So if at all, my lord, she has been removed from that particular school, there would have to be some orders.
Now, how can there be two schools? How government can say it's two schools?
My lords,
How can they give recognition to two schools by the same?
they don't give recognition, my lords. They say, now they very interestingly say that
No, see, it may happen
my lords,
that there exist two schools by the same name.
my lords.
But so far the government record is concerned, there has to be only one school.
Only one school, which is why your lordships
How
have,
come they come and say that
my lords, which is why your lordships had said that give me the bank details. Because the original school only would have a bank detail, my lords, where the money from the government would go. Fake school, there would not be any grant by the government. In respect of the original school, my lords, I am part of the managing committee. So if any money is coming, I would be aware that this money is going there only.
that becomes a kind of you see, like investigation by the court.
I'm sorry, my lords.
That becomes a kind of investigative work by the court.
My lords, your lordships had heard us at length, my lords, and that is what ultimately fell from your lords.
Mr. Paul, we hear many matters at some length, and then subsequently, because of this reason, that reason.
If it fizzles out, my lords, we all forget.
And if it is, say, supposing if the matter is postponed sometimes because of want of something, so much of time is taken by the parties that what was hard is forgotten.
My lords. As a matter of fact, I must confess.
Say, supposing if something is required today and if we have the matter tomorrow, then there is no problem.
My lords.
But then what happens? We pass it over sometimes for 2 days, and then the party comes and says, sorry, you could not get the instruction. Please.
Comes after 2 weeks, my lords, we all forget. My lords, I must confess, even I have also forgotten half of what transpired that day, but from what I can recollect.
Even you may find with you see, like the appreciation of matter by the court. Probably on the other day, court has on something else.
My lords.
Today you may find that court is on something
else. On something else.
But then the thing is that the problem is that, you see, like what was the argument?
My lords, your lordships had heard on the issue, my lords, that they said that there are two schools.
No, see, there cannot be two schools over the government record is concerned.
Absolutely, my lords.
So this is something will not be accepted.
My lords.
They will say that which is the, yes, in reality there will be two schools, but then government cannot have
in government records there can be only one school.
And then yes, and who is the main school? Who is the
which is the actual school? My lords.
That is only their documents of managing committee will show.
My lords, which is why your lordships had said that if she is part of the managing committee, my lords, which was originally approved was for a period of 3 years, some document would have to be shown that she was actually thrown out of that school.
What is the affidavit filed by the state?
My lords,
and then, what else? Just let us complete.
This is the sum and substance of the writ petition, my lords. I'll take your lordship straight to the affidavit.
So your claim is not confined only to that 78,000.
No, my lords.
Of course, that 78,000 also is not all
paid.
Your money.
My lords.
So your claim can be only for you. Others are not before this court.
My lords.
There is only one writ petition.
My lords.
Where are the others? Other four.
My lords, I think what the managing committee was trying to impress before this honorable court is some of them have taken some money and they have forgotten about it.
Now, you claim that you represent the original
school,
the actual school.
My lords.
Now, how do you say that? On what basis?
My lords, Annexure 1. I've taken your lordship to Annexure.
That had a limited tenure.
My lords.
Then thereafter.
My lords, because if I am a regular appointee in a government school, my lords, if I am to be removed from that school, there would have to be a formal order. The
managing committee is not you are alone.
No, my lords. My lords, my position is ex officio member. By virtue of being a teacher of the school, my lords, I am part of the managing committee.
See, this is a writ petition of 2014.
My lords.
In 2014, where were you?
My lords, I was a teacher. I continue to be a teacher.
Without receiving salary for such a long time.
My lords.
You are serving in the school, if you say from 2004, now it is almost 20 years.
I have been, my lords.
Without salary?
I have been. And that is why the petitioner has not given up on this, my lords. Everybody else has given up on this matter, my lords. It is only the petitioner who is continuing with it.
That is something very unusual that an employee is continuing in the school for 20 years
my lords,
without salary.
I am fighting a lone battle. I am fighting a lone battle, my lords. What had originally started with 4 people, my lords, everybody has abandoned me. I have still continued to fight. I have not given up.
No, but then you cannot run a school alone, isn't it?
I cannot, my lords.
Now, who are the else who has given up the fight and where are they?
Well, I'll have to seek instructions in so far as those other 3 people are concerned, but that may not be relevant for the purposes of this writ petition, my lords. But
well, we do not know. See, sir, the problem is that now the claim is not confined to your individual thing. Now you are basically, this thing has got diverted to school, two identities, two
My lords.
different schools.
My lords.
So once you say a school, it cannot be one man show.
No, it cannot be, my lords.
So there has to be a team for running the
My
school.
lords, the president of the managing committee is before your lordships. They file an affidavit
Say supposing-
affirming the fact that this is the school.
If at all you are a part of a school,
My lords.
then you are not alone there.
I cannot be, my lords.
So who are the others with you in that school?
The other teachers, my lords.
Whoever it is. the
My lords,
managing
that
committee
those
members
names
and
are
all those
available.
things.
Give me those names.
And are they recognized by the government?
Sorry.
Anyway, probably this court is going on certain things beyond what has been printed in the writ petition. Maybe we have to confine to that. Then we will just see what is stated in your writ petition and decide on these things. Because these will be unending things.
My lords.
We will
Because
just
what,
see-
my lords, what has emanated from the affidavit filed by the respondents is that that's where the plea comes that you have been terminated and you have gone and set up another school.
What do you- what
Original
do
school
you-
is somebody else.
What do you say in your writ petition about the false school?
At that point of time, I am not aware that there is any false school.
2014.
I'm sorry, my lords.
2014 you filed the writ petition.
Lordships.
No, but then your prayer says false school.
My lords, I'll take your lordships to that, my lords.
Just take us to the statement which you have made with regard to the false school. Because in page 18, your
I've seen
prayer
that.
you
I've
just
seen
said,
that, my lords. Your lordships are correct.
Given to false school. Now, once you say false school, then there has to be at least some narration how and where this false school is functioning.
My lords, page 14, paragraph 17 onwards.
Yes.
Your lordships have it.
Yes, yes, I'm there, please.
The petitioner begs to state that after shifting of the Rajpur Girls Upper Primary School to its present place in pursuant to the resolution adopted by the General Meeting dated 24/2014, the petitioner has been discharging her duties in the capacity of headmistress but sincerely for the satisfaction of all concerned. But the then Secretary of the School Managing Committee, late Mokhtar Hussain, with the help of official respondents, established another school in the name of Rajpur Girls Upper Primary School and appointed new teacher including his daughter Miss Tanuja Begum, and has been receiving the benefits sanctioned by the government, thereby depriving the petitioner and other genuine teachers of Rajpur Girls so-and-so school. In this respect, the petitioner and other staff submitted several representations before the respondent number so-and-so with a prayer for releasing areas, salaries, current salaries and other government benefits to the genuine teachers of the Rajpur Girls School and stop the benefits in favor of the fake teachers. These representations are there, Millets. Then 18 Millets. That Al Farooq Hussain, assistant teacher of the school, voluntarily resigned from his post and therefore through a journal meeting dated 12/4/2005, one Shri Tanjit Mehboob has been appointed as assistant teacher of so-and-so and has joined his duties from so-and-so. Another teacher, Srimati Hamida Khatun, also voluntarily left the school and joined another school. And in her vacant post, one Tehrul Islam Mondal has been appointed in the general meeting so-and-so, an assistant teacher, and he joined the duties on so-and-so. Presently, the teaching and non-teaching staff of so-and-so, the query that fell from your lordships, Faluda Biswas, Mofidur Rahman, Tanjit Mahmood, Tahirul Islam Mondal, and Abul Hussain. That the petitioner begs to submit in compliance of the Honorable Court's.
Who was holding the managing committee of the school at that point of time?
Who, my lord?
Who was holding managing committee of your school at that point of time?
In 2014, my lord.
2014, when you made
2005, my lord.
Now, your writ petition is 2014, isn't it?
My lord.
Now,
2005, these appointments are made in 2005.
see, paragraph 17, you have said
My lords.
that about the start of another school by
My
the
lord.
same name,
My lords.
isn't it? And
My
you
lords.
filed a representation 2014,
My lords.
isn't it?
Yes, my lords.
Now, 2014 representation, it is filed by you individually,
11 and 12, I'll just take a lordship.
not by managing committee of your school.
I'll just take a lordship. Yes, my lords, it's in my individual capacity.
So there is
As
no managing
headmistress of the school, my lords. As headmistress of the school.
Okay, so there was no managing committee. You are headmistress, and then who was the secretary of the managing committee at that point of time?
My lords, those instructions.
Did you have any recognized managing committee at that point of time?
My lords, the managing committee must have been renewed from time to time.
Well, that must have been is one term. You see, like you see, we are to decide a matter.
My lords.
So we cannot decide on anything on the basis of.
My lords, the state in its affidavit has not brought on record anything to show that there was no valid managing committee.
The problem is that there is no clear-cut evidence by statement by you. That you see.
saying that they cancel the recognition of given to the false school. Nothing is there.
There is no recognition given, my lords. What I'm trying to humbly submit before your lordships is, there is a school, my lords. There is a grant coming to that school. There's a decision to shift the school building from point A to point B, given effect to. What the secretary, my lords, he does is, he continues to run a school in that same place. And the bank account of that particular school, my
Problem
lords,
is that you see, the incident which you are referring just now, it's happened 20 years back, more than 20 years back.
my lords, 2004.
But thereafter, that is why the court was asking me a question that how could you teacher continue in service for 20 years without salary, without making any serious grievance. You file a case, you casually remain there, allow these cases to run in normal course.
My lords, I have been before your lordships ever since.
See, had it been such a serious thing that you see another school has been started by the same need,
My lords.
the situation should have been alarming for you.
My lords, it was. That is why I'm before your lordships.
It seems nothing there. You see, like
My lords, because this is the
give a disclosure about the institution of managing committee after that the very managing committee which you pointed out, term of that lapsed in 2005.
that lapses not in 2005. My lords, that doesn't lapse in 2005. That lapses. I'll just give your lordships the date. It lapses in 2006, my lords.
That's okay. And thereafter what happened?
These appointments, what we're talking about in para 18, my lords, is all in 2005.
Thereafter, who constituted the managing committee? After 2006?
My lords, the state would be in a better position to apprise your lordship.
School, you say that you were holding your headmistress. You filed representation on behalf of the school.
My lords.
So at least you should give us the information.
My lords, I'll have to seek instructions. At this stage, I don't want to do that. But, my lords, the records would definitely be
it
there.
means like there is no information so far as those things are concerned in your writ petition.
In the writ petition, there is no averment.
It goes that way. If something is not there, definitely we cannot help it. It's not
My
there.
lords.
Yes. Okay. So you are not in a position to say that which managing committee, you see, like was instituted there.
My lords, at this stage, I'm not in a position to say, but
Now, even at least you would know one thing, that the school where you are running, it had a managing committee or not?
it had a managing committee. My lords.
Who were those managing committee?
My lords, one is the respondent, my lords, who has filed an affidavit before your lordships.
2006.
I'm sorry, my lords.
After 2006, you were serving continuously in the school, isn't it?
My lords.
So it means it cannot be a one-man school.
No, my lords, there has to be a duly constituted managing committee.
Then who was the managing committee which was running your school?
My lords, that averment is not here. That is the difficulty.
But then otherwise, who was there? Can you say us? You must be personally, at least, you personally know who are the managing committee.
My lords, I would be in a position to do that. I can file an affidavit bringing on record, my lords, from 2006, who was there.
It's too late to file an affidavit. These are all matters pending.
My lords, these are queries which are falling from your lordships at this stage, so I'm a little handicapped in responding there.
You see, if these informations are not there, we'll take it that way.
Well,
We cannot decide anything by presuming. This is a writ petition of
because
2014.
the state does not deny this, my lords.
See, this is a counting. If you are serving in a school,
My lords,
presume that there exists a managing committee.
my lords,
Now, here it is seen that the allegation of, you see, like establishment of another school by the same name, everything comes from only from you. Now, if you say that there at all was a school and it was managed by a managing committee, recognized managing committee, where you were a part, then definitely there has to be a continuation of that.
that managing committee is continued,
So
my
then
lords.
how it continued after 2006? That is what this court
My
is
lords,
asking.
through due
There is no
notifications.
evidence in your writ petition to show that this
Because
managing
that was
committee-
not the issue before your lordships at that stage, my lords. I am not required to disclose that.
No, but then the issue.
My lords, if had that been an issue, my lords, material to the decision of this case, my lords, I'd have to come before your lordships with that.
issue which you have raised before this court to decide that we need those information.
My lords, that is borne out from the affidavit of the state.
Now, which
State does not deny the fact, my lords. State does not deny any of these governments. They simply say,
But then you said that state has come up with that contention that
my
there
lords,
is
the
issue.
state comes up with a contention saying that there are
Definitely
two
we'll be
schools.
We'll ask them then what is this source of information? How they say.
My lords, I will take your lordships to the affidavit of the state.
Asking so many questions to you
My lords.
doesn't mean that we give them a.
No,
safe
my lords,
answer.
I bow
They
down,
will
my
also-
lords.
They will also have to come.
My
to
lords,
us.
what I am saying is, my lords, at the stage of filing the writ petition, these issues were not, my lords,
These issues are very much relevant at the time of filing of the writ petition. You have not included it, that is a different thing. Probably you thought that at that point of time that may not be necessary.
At that point of time, my lords, probably
See,
that was the
but then to determine a situation which kept pending for more than 20 years, court is very much interested to know. Because after all, this court will have to give a finding which school is the actual and the real school.
My lords.
If at all, if it comes to that.
If it goes to that extent.
Then on what basis?
No, because the plea of two schools, my lords, it comes into the affidavit of the state, my lords. I'll take your lordships to the affidavits of the state. How do they respond to whatever I've said?
Also, you have said about false schools.
Writ, my lords, I must bow down. It's a little sketchy. But probably, as your lordships rightly said, my lords, at that point of time, probably it was not thought appropriate that these were the issues that would have come into, my lords, play at the final time of final adjudication.
See, the problem is that your claim is not with regard to salary for a particular period of time.
My lords.
You pray for continuous.
My lords.
Okay, the payment of the continuous salary.
My lords.
So that is what the problem is. Now to order that, this court will have to determine whether you are at all entitled or not, or your managing committee is at all entitled to get it or not. That's the main
Because
thing.
what we are saying is, my lords, the money continued to be granted by the state to the managing committee. It's not an isolated incident of 3 months.
See, managing committee, it was granted to the managing committee.
My lords.
So definitely some managing committee has withdrawn it.
My lords, it has.
Okay. Now if you say that it is not by your school, then the other school.
What I'm saying is, my lords, the managing committee withdrew the money and continued to misappropriate the money, giving it to somebody else who are not probably the original teachers of the school. That is what my submission before your lordships.
So that is all right. But then if you are serving in an original school,
my lords,
how could it go to some other teacher?
I have not gone, my lords.
No, but then you are the headmistress. The problem is that is why court is repeatedly asking you that question, where is the managing committee of your school? There are certain things. So supposing if this salary was diverted to some other school, then your managing committee should have reacted to it.
My lords, that is what I'm saying, that the managing committee
not
was...
for you alone to react it.
No, I'm not, my lords. What I'm submitting is that the money is being disbursed by the government to the school. There is one managing committee, my lords, one bank account. That money is going to that account. Now, from there, my lords, it's going somewhere else.
No, is there any shift of this thing, bank account?
No.
After this alleged this thing?
No, my lords, that's what the state has come.
It
It is going to the proper account, but it is not being disbursed where it should be disbursed.
So it means you have a claim against the managing committee then.
Lordships.
So you make a claim against the managing committee and who are the managing committee who has taken it. Because it is not one managing committee who is functioning for
My lords,
20 years.
every managing committee after that, because now in the affidavit filed before your lordships by the state, they say that we are giving money to the managing committee. Managing committee is giving it to the teachers. You are not a teacher. That is the case that is projected before your lordships. Now, what your lordships would have kindly seen, my lords, my appointment at the school is not disputed. 2, my lords, in 2002, I was very much part of the managing committee. If I have to be removed from the school, or if, my lords, there is an order of removing me from the managing committee, there would have to be some formal order. It cannot be done at the whims and fancies of somebody.
Now, say supposing if you move out to school of your own,
my lords,
even that case also there has to be an order.
There has to be a formal order, my lords, that it would be an act of...
Ousting you from service.
It would have been an act of indiscipline.
Definitely unauthorized absence.
Unauthorized absence, my lords, setting up another school, there would have probably been an FIR for opening up another school by the same name. There would have to be a formal order saying that you are hereby terminated.
So once it is not there, then it has to be presumed that you are
The
continuing.
presumption would then be in my favor, my lords. Presumption will then be in my favor.
That they will have to reply to that.
My lords, my humble submission before your lordships, presumption then comes in my favor. What was falling from your lordships, my lords, there is only one school. This entire idea of, my lords, 2 schools and the money going here, it is basically for defalcation of public funds. The president, my lords, has filed an affidavit before your lordship saying that yes, indeed, the school building was shifted from place A to place B. That would have no material bearing in so far as, my lords, the funding by the state is concerned. Because the bank account would be the same, money would have to go to the rightful places. So if the money is being disbursed to A, B, C, my lords, they would have to show that A was appointed on so-and-so date, regularized on so-and-so date, this is the money which is being got from the government, this is what we are paying. I have shown before your lordships, my lords, that I was very much appointed, I was part of the managing committee. If, my lords, it is the case of the respondents that I have subsequently...
They will have to clarify it, how you discontinued to be a part of this school.
My lords.
So that is what they will have to establish.
My lords.
But
Because if...
otherwise, see, like every contention of yours,
My
you
lords.
cannot ask them to counter it.
No,
The
no.
burden is on with you.
My lords. I am only saying this, my lords, that I continue to be part of that original school. There is no question of, my lords, me going and opening up another school, because that would be a gross act of indiscipline for which there would be proceedings against me. Second, my lords, there would have to be a formal order removing me as a teacher
Yes.
and as part of the managing committee.
But then, do you say that there is no order removing you from the
Yes,
school?
my lords.
Where is that statement?
In my rejoinders, when they say...
Rejoinder cannot see. Rejoinder, do they reply to the rejoinder?
My lords,
Make your contention in the thing, writ petition.
no, my lords, because at that stage there was no contention of saying that I have gone and...
Rejoinder is only for the purpose of clarifying certain things. You see, like rejoinder cannot be for the
No,
purpose
my
of
lords, what had happened is, at this stage, this plea was not there that I have been terminated or I have been removed. When it came, I have responded. They said that you are not even a government teacher. My lords, I have given my...
they said in their affidavit that you have returned.
Lordships.
Now they have not unclosed any order.
Nothing.
Now you countered it by saying that you have not been returned.
I have not been terminated.
Okay, so we take it as this.
Lordships.
That is all right.
They also say that you are not a government teacher. To that extent, my lords, I filed by you. There is this registration that is done of teachers, my lords. I filed that as well.
No, but then you see, like you are a part of school that cannot be disputed because you are a part
My
of
lords, that is what is sought to be disputed before your lordships.
No, that is a situation in 2004 or 3 or whatever it is.
My lords.
But then, if there is a change later on, then how the change came, whether you, what responsibility you had, or whether you are responsible for shifting the school or not, that has to be determined, and then we'll just see what the government says in their affidavit.
My lords, I'll take your lordships to the affidavit filed by the government.
So let the state, if you want to specifically point out something, definitely
My lords,
you do it.
Then let them, my lords, place the affidavits. Then I'll just in my rejoinder, my lords.
There are many things which you also have to reply. You see, your replies are not very satisfactory, because the thing is that even that thing remains. That how come you become a lone victim of a school, if at all, if you are with the real school?
I'm sorry.
How come you become sole victim?
Victim, my lords.
If at all you are with the real and the actual school.
My lords.
There has to be many sufferers. How come you be sole victim? That is the main thing.
I am not the sole victim. My lords, I am not the sole victim. There were these 4 teachers.
But then they are not before this school.
My lords, what happens is, what your lordship rightly pointed out, that this litigation has been going on for 20 years.
At present, if you claim that you are still functioning in the school,
My lords.
you are not functioning there alone. There must be other teachers.
My lords, I have just pointed out the names of the other teachers before lordship. My lords.
So, but then they are not before this court.
My lords, they are not. They are not.
That is good enough to show that they do not have any grievance. Yes.
My prayer, my lords, but my prayer, your lordships would have seen, my lords. Of course, it is very sketchily drafted. There are certain. My lords, I have bought a tight wicket on that.
Of all we understand. But then, you see, this court is there for rendering substantial justice.
Lordships.
So that is what the many things which may not be very essential court may overlook.
My lords, absolutely.
But then we have to determine that whether you are an actual teacher or not, and if you are an actual teacher, then such a thing should not be deprived of yourself.
My lords.
That becomes the prime concern of the court.
I'm grateful, my
But
lords.
at the same time, if there is your statements or your contention before the court is not correct, then you are not entitled to
No, then I will not be entitled to it.
So that is what is. See, the tough task is for the court is to determine it, especially when you see like what to say, both the parties are sketchy before this court. You see, like they have adopted. You see, not to narrate facts in a straightforward.
Lordships. What has happened here, my lords, if I may
Now,
humbly submit before lordships, my
if you
lords.
are crafty in placing facts before the court, that becomes difficult.
Lordships. Well, I must humbly submit before lordships. What has happened is in these last 20 years, because of these numerous rounds of litigation and the numerous affidavits that have come, things have got a little, my lords, distorted here and there. As your lordships have rightly said, probably the pleadings.
On your part, if you claim to be a teacher running without salary for 20 years, was it not your duty to speed up the things?
My lords, your lordships would have kindly seen.
A writ petition filed in 2014 pending for 10 years.
My lords, because repeated affidavits have been filed. The matter is being heard, well as I think this is the umpteenth number of times that this matter has been heard by your lordship.
This court was connected with the affairs of the High Court for more.
I'm sorry. Lordships.
So how things works here, this court has some idea.
Lordship.
There is no reason for keeping a matter pending for 10 years.
For so long.
Until and unless the parties intentionally desire to. Otherwise, no. Yes, you have anything more to say, Mr. Paul?
Subject to what they say.
Your Lordship, I would like to
You are
take.
appearing for?
Your Lordship, for respondent number 10 to 14.
So your claim here, the claim against you is confined to rupees 78,000.
Yes, Lordship.
Nothing beyond that.
Your Lordship, only that portion only, Your Lordship, I want to explain. Your Lordship, after there's a direction for registering a criminal case, Your Lordship, then the case for Fulbury PS case number 71 2014 under 40934 has been registered. Your Lordship, this I'm taking Your Lordship to the affidavit filed by the state, Your Lordship.
You have not filed any affidavit?
I have filed, Your Lordship, but
okay, it's all right. But then,
may I read
why you
your
are pointing out to the state affidavit? State will place it before us.
No, Your Lordship, regarding that criminal case, Your Lordship, the investigation of that criminal case. Only that, for that issue only. May I read, Your Lordship?
Just a minute. I'll just take note. That's all. You're for private respondent number?
10 to 14, Your Lordship. I mean, clarification only on that criminal case.
The government.
Yes, Lordship. First affidavit, this is May 2015, Your Lordship. First affidavit filed by the state government.
First affidavit filed by the state. Thirteen, is it?
Here's only a month
9,
of May.
10, 11, 12, 13 and 14. Affidavit filed by on behalf of respondent number 9? No.
No, Lordship.
Then affidavit opposition filed on behalf of the respondent number 1 to 5?
1 to 5, yes, Lordship.
That is 22nd.
Your Lordship?
Is it dated 22nd May?
Yes,
2016?
yes.
22nd May.
I'd like to take Your Lordship to paragraph 5, Your Lordship.
Just a minute. Let's first find it out. Yes.
Paragraph 5.
Yes.
The last 6 lines, Your Lordship, from that page.
Yes.
Whether Your Lordship has got the said case has been registered.
Yes.
May I read, Your Lordship? In the course of inquiry investigation, the investigation officer found that the salary amounting of rupees 50,000 meant for the teachers has been disbursed to the teachers appointed by the managing committee, Raj Girls Upper Primary School, and has been duly approved by the Joint Director, Darangiri West Garwas District. The statement of the teachers has been duly recorded by the investigation officer, wherein they have stated they have received the salary for the year 2004-2005 as sanctioned by this SSA. The statement of one of the teachers, namely Srimati Ruxana Ahmed, however, could not be recorded due to the fact that she has left the school after
She is not Ruxana, isn't it? The petitioner is not Ruxana.
No, Lordship. One of the teachers.
Yes.
She has left the school after her marriage and settled in Saudi Arabia. It is pertinent to state that even the remaining salary of 28,000 has been withdrawn by the administrator, Rajput Girls Upper Primary School, who was also the Deputy Inspector of School, the Darangiri Subdivision, and the salary has been paid to all the teachers. The only person who did not receive the salary amounting to 9,400 only was the petitioner, who refused to accept the same, as she demanded that she be appointed as headmistress of Rajput Girls Upper Primary School. This was revealed to the investigation officer during course of investigation in Pulbari case, so and so. This is only point I want to. The outcome of that criminal case. Yes, sir.
This part
yes, sir,
of the evidence, if it is accepted, then it exonerates you.
Yes, sir.
You have no responsibility.
Yes, sir.
Otherwise, this private respondents, what is their status now? These private respondents, they were part of that managing committee.
Part of that managing committee, 2004.
At that point of time. So
that
they are
point.
nobody now.
Nobody.
And if there is at all any claim to be made from you individually, then it cannot be by a writ petition.
Correct, Your Lordship.
There is no evidence to show that you had a hand in this
Yes, Your Lordship.
manipulation of the
Yes,
salary.
even that criminal case also.
Okay, that ends your submission.
Yes, Your Lordship.
Okay.
That's one.
Yes. Now, why the state is coming last?
Because they are the one who has created all the hodgepodge, my lord. Let them wash it later on.
You are who?
I am the president, the then president, my lord.
At present.
No, my lord.
Then?
President at
of-
that point of time, my lord.
Which point?
Where he is claiming the salary, my lord. 2004, my lord.
2004-5.
Yes, my
Now, where are you at present? What is your position? You have no position.
No position, my lord. I'm an old man, my lord.
So is it not that Mr. Kheriam's submission covers up your situation? No.
Yes, my lord. But there is some hodgepodge which was created by the government. The entire thing has been messed up by the government, my lord. My lord, may kindly see.
You are respondent?
I'm respondent number 9, my lord.
Only 9.
Solomon Hawk, my lord. I have few submission, my lord. No doubt, I have full sympathy with the client of Mr. Senior Counsel, Mr. Pal. But my lord, if my lord coming to the first the writ petition, my lord. The writ
petition, sorry. Oh, achha, that earlier one disposed of.
No, my lord. The present writ petition, my lord.
Yes.
If my lord kindly come to page 17, my lord. I have full sympathy, my lord. But he may hit me with my affidavit. So I'm saying I have full sympathy. But only thing is this, it will be difficult for this honorable court, my lord, to allow this writ. Because of what reason I'm just pointing out, my lord.
Now, if you do not have a stake right now, which way it affects you? Whether we
No, it is not affecting. I'm just pointing out, my lord, because I've been made a respondent. I'm just pointing out as an officer of this
okay,
court, my
writ
lord.
petition, para?
Not para, page 17, my lord, the prayer portion, my lord.
Yes.
My lord, may kindly see the first prayer, my lord. Recovery the salaries of the teaching and non-teaching staff. Non-teaching staffs are not here, my lord. Even the other teaching staffs are also not there. Only petitioner, my lord. Second thing is that, my lord, the managing committee of the school and further directing the respondent authority to release the current salaries. Now, if current salary is required to be paid, my lord, then the managing committee should have been, the present managing committee should have been made a party. That is not there, my lord. The third thing is this, my lord. Area salaries and other government benefit in favor of the petitioner's school, namely so and so, and to
in this petition, just wait, one second. In this petition, the managing committee, which was existing in 2014, has not been made a party.
Yes, my lord. Yes.
Though there was a prayer for current salary, but then they have not been made a party.
They have not been made a party. Now, my lord, we can see to stop the benefit given to the false school.
They are party, my lord. Respond number 14. The
14?
school is a party.
No, my lord. What I am saying is current, my lord, because she
Current,
is
current.
also claiming for the current
managing
salaries.
committee
Also.
is a party. Whoever steps in there.
But my lord, but my lord, whether the new managing committee will be answerable, my lord.
Managing committee is represented by secretary, isn't it?
Yes, my lord.
Then it's okay. Whoever will be
My lord.
secretary.
But now, my lord, here to stop the benefits given to the false school in the same names and after perusal of the records and causing of so and so, my lord. Now, my lord, the false school, where is the claim and counterclaim of the petitioner and the state government, my lord, they are not before this honorable court. Even if my lord want to pass an order, without hearing them, my lord, how can this honorable court pass an order, my lord? They are not before this honorable court.
If there is at all any allegation, of false
Yes,
school,
yes. That is.
Then who is that false school that has not been identified here, and they have not been made a party?
Yes, my lord. Now, my lord, if my lord may kindly see, I was the person, my lord, in writ petition number 99 of 2004, my lord. I have come before this honorable court for releasing the salary of the petitioner, my lord. At that point of time, my lord. I am not talking about the current. At that point of time, my lord, when she was serving, I don't know at present what is the status, my lord. At that point of time, I have come before this honorable court, my lord. There was an order of this honorable court, my lord.
2004.
2004. This order was passed in writ petition number 99 of 2004.
Whether Mr. Paul knows about it.
Yes, definitely. No, my lord. I was then applicant. This is an order.
This is 2005.
This is an order, my lord, whereby, my lord, the Deputy Inspector of School, Dadangiri, has directed, my lord, to the Secretary and President. At that point of time, my lord, I was the President,
non-payment of teachers' salary under the SSA school scheme, my lord.
Yes.
Now, it has come to the notice of the undersigned that you have not paid the salary under SSA to the teachers of your school. You are therefore directed to make necessary payment of the same completely within 1 week, failing which the undersigned will take necessary action, which may please to be noted. Now, my lord, the stand of the government is this was a fake school or there was no such school. If no such school, then why the Deputy Inspector of School is issuing this order, my lord? What I have submitted at the first instant, my lord.
This court did not get your submission.
Well, my submission was this. At that point of time, there was a writ petition which was pending before this honorable court, my lord. I made a miscase, my lord.
This writ petition was pending, questioning what? But for what? For that?
For non-release of salary, my lord. Non-release of salary.
This was filed by you.
This was the miscase was filed by me, my lord.
No, this is an order in the miscase.
Yes.
Now,
yes.
in this miscase, what you wanted?
I wanted.
Petition and what is the
my prayer was this, my lord, that the salary, which was already withdrawn by the secretary, should have been released, my lord, as per the order of the Deputy Inspector of School. The Deputy Inspector of School.
You are the president of the managing committee.
Yes, my lord.
Now you have to come to court for seeking a
direction.
Why?
Because the secretary was not disbursing the salary, my lord. So the president has come before, my lord, before the.
It happens that the president approaches the court,
my lord, but
for making the secretary function properly.
Yes, my lord. But this is very. I don't know, my lord, what was the intention of the gentleman. But from the paper, it appears, my lord, he was a good man. That is why he need to come before this honorable court.
Then anyway, then you refer to this letter.
Yes, my lord.
Yes.
Now, my lord, if my lord may kindly see the last paragraph. Any order passed today in this regard and also payment of the salary to the teacher shall be communicated.
Not legible.
My lord, if my lord.
It's not at all legible.
These are all typed copies, my lord. So.
This is not a type copy. This is
the last para, my lord, may kindly.
Yes, at least here it is bit legible. There it is not at all legible.
My lord has to read, my lord.
So you do not have a good copy?
No, my lord. I was thinking, my lord, it's readable, but even me, my lord.
Yes. Then what happened?
Then, my lord, there was an order to release the salary, my lord.
But then that was supposed to be invited to the intimation to be given to the government advocate. Then.
Yes, my lord. And the miscase stand disposed of.
Now,
so my miscase was disposed of, my lord.
What this order has to do with this in this case, present matter?
The first round of litigation, my lord, where in 2004, my lord, the matter has issued, my lord, or cropped up, my lord. So my stand was this, my lord, that the money which has been disbursed by the government, it was in the bank of the managing committee. President and secretary goes to the bank, withdrawn the money. It was handed over to the secretary.
Okay, there is no responsibility fixed on you.
Yes, my lord.
The inquiry is concerned.
Yeah. So I just want to point it out, my lord, that what was my conduct at that point of time, because it was the president and the secretary. They have gone to the bank to withdraw the money, and the money was handed over to the secretary for disbursement, my lord, to the teachers. That was my stand, my lord.
So far as the materials on record is concerned,
my lord,
what is found here is that it was the secretary who was solely held responsible.
Yes.
For payment.
Yes, my lord.
And he is no more.
He is no more, my lord, now.
And just because he is passed away, that responsibility cannot be shifted to others in view of this specific categorical finding.
Yes, my lord.
Okay.
I'm just clearing my name, my lord, because already there is an inquiry also. My name was not figured out. I am pointing it out, my lord, if it's all.
So you are not responsible for the money?
Yes, my lord.
How do you recover money from a dead man?
Which is why I am saying, it cannot be anybody, nobody can wash their hands off. There would be, some kind of joint responsibility also of the management.
Not by himself.
I'm
it
sorry?
is automatic.
By default.
Now, how do you recover at all if you find that you are entitled to some money? How do you recover it from a dead man?
Well, it's the managing committee would be responsible.
Until and unless the managing committee here,
because the managing committee acts collectively, Milaj. The managing committee acts collectively. One person may have been given the money, If he, well, it's the reason why we have a managing committee and
for
not a
all
management person.
So far as the administrative decision is concerned, okay, managing committee becomes entirely responsible.
Well,
But then when it comes to, you see, the day-to-day work, if certain duty is to be discharged by secretary, it will be only secretary who will be responsible.
but Malaj, somebody would have to take responsibility. It cannot be merely because there is a body, Malaj.
That somebody
A,
is
ma-
no
a,
more-
magic, a managing committee is a body. It is a juristic person, Malaj. So we cannot say that merely because one of the constituents of that body is no more, Malaj, the responsibility would be, they would be absolved of all other liabilities.
No, I do not know. This is very difficult situation until and unless you show something in law that in this kind of situation what happens. This court is
My humble submission would be if there is a committee, Malaj, that the members of the committee would be jointly and severally responsible.
But then is it not that the subsequent inquiry report, this which the order of inquiry was
Maybe, Malaj, that
obtained by you in a writ petition?
if I am a member, if I may just draw an inference, Malaj, if I am a member of a committee, Malaj, there are 5 people in that committee. We are all jointly and equally responsible for any action of that committee.
See,
I may have been, Malaj, at the behest of Malaj, the president might, under good faith, might have given it to the secretary.
see, there are certain decision which is collective decision of the managing committee.
Malaj,
There are certain decision or certain action which is individual.
Malaj, I am saying that
Now, if a member of a managing committee,
the action of disbursement of salary, Malaj, cannot be a individual act.
see, there are certain things. If any member of the managing committee steals something from the school property, can the responsibility fix on the entire managing
Malaj, then the rest of the managing committee should have gone to the police at
Anyway,
that point
it's
of
okay.
time.
It's okay. You see, like nothing, I do not know. You may have this thing, but then until and unless you are able to show, that becomes very difficult.
Malaj, my humble submission would be they would be jointly and severally responsible.
It's all right. We understood that. Yes. Yes. State. Come this side, please.
We have already filed our affidavit. and
Yes.
it was
What do you
relied
say?
upon- It was relied upon by the managing committee.
That is so far as the
Inquiry is concerned.
police case is concerned.
Yes, my lord.
Yes.
That has come in the first affidavit, my lord.
How many affidavits are there?
There in on behalf of the state, my lord, there are nearly
Just tell us,
3.
Before you come to other thing, tell us in which manner this petitioner got disconnected from the affairs of the school.
My lord, that is for the managing committee to answer, my lord, because we are the approving authority. We are the approving authority, my lord, and the action which you are taken by the managing
Which
committee.
managing committee will answer that?
My lord,
Tell us from which date she got disconnected.
my lord, what we filed in our affidavit is that there was a resolution taken by the managing committee that then managing committee.
What is that resolution? Where it is and what is the date of that?
They say that she's been removed. Where they say that she's
Now, how this petitioner was taken into service? Mr. Sengupta, how this petitioner was taken into service?
I think the petitioner will be in a better position
why
to.
you think? You just say what is as per your record.
No, as per my affidavit is concerned, my lord, we have brought on record the termination letter, my lord, and the after inquiry, my lord.
Termination letter.
Yes,
of the
my lord.
petition.
Of
Okay,
the
where is the
petitioner.
termination letter?
That is
That will be relevant. Just show us where it is.
No, that is in the affidavit filed by the administrative officer on June 2019, my lord.
June 2019.
Yes, my lord.
Yeah, 7/6/2019.
It is at page 10, my lord.
What? One second. Let us just first come to 10 June. Is it?
Yes, my lord. 10 June 2019.
Now, how many affidavits are allowed in a writ petition?
My lord, from time to time, different issues were brought up, and we had on one occasion there was a inquiry to be conducted by the director of education, my lord, and he also has filed another additional affidavit.
Yes, just a minute. Just a minute, Mr.
This is on the issue on which the court had asked you to see instructions.
My lord, this was an additional affidavit by the administrative officer.
Yes. Where it is?
Page 10, my lord.
Page 10, my lord, is the termination letter issued by the secretary Rajpur Girls Upper Primary School.
Page 10.
Yes.
Okay. So there is termination issued in which date it was? 16/7.
16/7/2004. And the prior to that there was a resolution by the managing committee.
Okay.
Managing committee resolution was 15/7/2004.
Just a minute. Just a minute. Now, this appears to be a relevant thing. See,
Well, this is when your lordships had sought instructions from the state. I must just fill in, Melits. I'm sorry to interject. The date is very relevant, Melits, 16/7/2004.
yes.
Melits, this is allegedly issued on the basis of the resolution at the next page at 15/7/2004.
Okay, okay, let him finish. We'll come.
Melits. I just, Melits, just trying to fill in what had transpired on the last occasion because even I had forgotten. This was flagged, Melits. That is why your lordships had sought instructions.
Page 11, my lord. May I read?
Just we just let us take note for what you are saying.
Yes, my lord.
Otherwise, this will have no.
According
to you, there exists a valid termination order.
Yes, my lord.
Which was issued on 16/7.
Yes, my lord.
So after 16/7, she was no more a part of the school. Now, what
Not
was
challenged,
the,
not
on
challenged.
which did the term of the managing committee ended at that time? That managing committee, which was in existence at that point of time?
My lord, will
2006.
2006.
Part of the writ petition, page 20. Page 20.
2006.
31/12/2005. It was valid because as per the annexure provided in the...
It continued after that also.
I was reading.
Mellows may also kindly have a look at page 11, Mellows, who are the members
Yes,
present.
definitely.
That was the issue that had fallen for consideration.
And the typed copy is given at page 15, my lord, of the resolution.
Page 15.
Page 15 is the typed copy of the resolution of the managing committee.
Yes.
An emergent managing committee meeting of the Rajpur Girls Upper Primary School is held today, the 15th July 2004 at 11 am in the school premises. As the president of the managing committee is absent, the quorum members unanimously propose Sir Noor Hussain to conduct the meeting, and under his presidency, following resolutions have been adopted. These are the 9 members, my lord. President Mukhtar, Subeda Khatun, Saidul, Tanuja Begum, 9 of them. Resolution number 1. It is resolved that the House asks the Secretary of the Managing Committee whether Srimati Faluda Biswa, Assistant Teacher of the school, has intimated or sent any satisfactory reply to the Secretary regarding the show cause notice issued twice against her. In this respect, the Secretary informed the House that Faluda Biswas neither intimated to her personally nor sent any reply to her in black and white. Resolution 2. After much discussion, it is resolved that the meeting unanimously decided to terminate Srimati Faluda Biswa, assistant teacher of the school, from her service, as she is found absent in her duties from consecutively 3 months, and she did not intimate the managing committee why she is absent from her duties, though a show cause notice issued against her twice. In this respect, the Secretary is empowered to do the needful and issued the termination letter to Srimati Faluda Biswa's assistant. This was the
So
resolution.
it means the police report says that she was demanding the post of the headmaster.
Headmistress.
And then this says that she was unauthorisedly absent.
Unauthorisedly absent.
So it means, it follows that since she was not given the post of headmaster, she was
Headmistress.
not
They were in disagreement.
okay. So after she terminated There is no question of her continuing this.
continuing in the post. And thereafter, according to us, my lord, it appears that the other school came into existence. So there is definitely, and in our affidavits also, my lord, subsequent
Other school
affidavits,
came into existence means the false school.
the fake school.
That is by her, isn't it?
Yes.
Now,
This termination was not challenged, never. My lord, thereafter, my lord, another additional affidavit was filed by the Director of Education in pursuance to our order from this honorable court, my lord. This affidavit is dated 24th August 2022, my lord. This is also an additional affidavit. In person,
any response was filed to this additional affidavit?
which one? This last affidavit dated 24th August 2022.
That's, yes. Was there any response filed?
Yes, yes, my lords. We filed rejoinders to all of them.
All the affidavit.
All the affidavits.
And what did you say against that their stand of that you have been terminated from service?
Well, we say that I cannot be terminated, my lords, because I was part of the managing committee. Which is why I drew your lordship's attention to page 11.
No. So far as this these letters are concerned, the termination letters are concerned, what do you say?
My lords, these letters were never there. As a matter of fact, the same officer files a subsequent affidavit saying that there is no formal order.
We have filed a rejoinder to this affidavit.
Yes, my lords.
Now, what is the statement where you say that she has been terminated from service?
Take out the response. Para 2. No. As a matter of fact, the affidavit does not talk about the termination.
But this was part of the documents which was forwarded by our officer dated 8th March 2019.
The affidavit does not talk about termination, my lords, which is why there was a direction to file a subsequent affidavit. In the subsequent affidavit, the same officer says that there is no order of termination.
No, man.
Yes, it is on record.
So why you are placing this if your officer by...
The same officer has filed an affidavit on 27/2/2020.
Mr. Sankrupta should not have placed it the same on record. At least if they say that there is no
Same
termination.
He says, my lords, there is no formal order of termination.
By the state?
My lords.
No, but then...
No, by anybody. What he says is, this issue came for consideration, my lords, and he was directed to file an affidavit, and he says, what he says, my lords, in the subsequent affidavit is, SSA was signed and sealed on the body of the resolution without there being any formal order.
Where is the subsequent affidavit?
My lords, this is dated the 27th of February 2020.
Sir, all unnecessary things, unnecessary documents here. Most of the things are not at all necessary. Affidavit dated?
27/2/20. It's a 2-page affidavit, my lords. It is again filed by Mr. N. Bhumik.
The same person?
Same person.
2010. How many affidavits are there?
Well, I think from the state there are four affidavits. 5 affidavits.
27.2.
My
Yes,
lords.
paragraph?
Paragraph 2, my lords. Lordships have it, my lords. That the petitioner above named was appointed by the school managing committee by resolution number so and so dated 99, which was approved by the joint director SSA, and the same was signed and sealed on the body of the resolution itself without there being any formal order being issued by the joint mission coordinator. Similarly, the school managing committee terminated the service of the petitioner by resolution number 2 dated so and so, bearing the seal and sign of approval of the memo of resolution itself by the joint district mission coordinator SSA Dadangiri without issuing any formal order or approval of termination by the then joint director mission coordinator Dadangiri West Governance. And what is more relevant, my lords, if your lordships kindly have a look at page 11 of that affidavit, which my learned friend was referring to.
copy file misplaced.
Yes.
No formal order, right? My lords, if I may draw your lordship's attention to page 11 of that affidavit which my learned friend was referring to. This is, my lord, what had fallen for consideration before your lordships, my lords, and I was trying to
Page
point
11
out.
is handwritten.
My lords, handwritten because the composition of the managing committee.
Yes.
First is, my lords, Noor Hussain is the president.
Yes. But
And your lordships would compare it with Annexure 1, page 20 of my writ petition. That is the approved managing committee.
But then have you taken all those studies before the writ petition?
In the writ petition, my lords, this document was never there. Subsequently, in my rejoinder, I have said.
You have filed a rejoinder to
Your lordships, I have.
Where is your rejoinder?
I'll take your lordship to the rejoinder. This is affidavit number.
My lord,
3, 4.
may I speak for a moment, my lord? The first paragraph itself explains it, my lord. In this page 11.
So far as the absence of president is concerned.
Yes, my lord. And
what about the others?
Other members are there. All the other members are which are mentioned in that list
my lords,
are there.
Absence of petitioner.
Not the petitioner. It is
managing petitioner is part of the managing committee at serial number 3.
No, but then you yourself are your decision was to be taken.
But it does not say that is why that I was.
In such a case, your partition may not be necessary, or maybe it was done intentionally that you are not supposed to be part of decision against you.
My lords, the other fact is that the number of persons available on this managing committee on this meeting are 9. 9 people
the
are
forum
present.
requires only 5 could fulfill the quorum.
Okay, so except for the president, there is no problem with it.
No, my lords, there is. What I'm trying to say is, Noor Hussain, my lord, signs as president.
Because of the fact that he presided over the meeting.
He cannot, my lords.
Anyway, it's all right.
He cannot. Mukhtar Hussain, my lords, is the secretary. Sobeda Khatun, my lords, is shown as ex officio member headmistress.
Where is your rejoinder to this?
My lords, I'll take your lordship. No, it's there.
To this affidavit dated 10th June.
No, that this is the affidavit filed at serial number 3. Then there will be an affidavit by petitioner. 2019, August.
My lord, what I mean to submit is that, my lord, there are several disputed questions of facts, my lord, which will be very difficult for the writ court to adjudicate and give a justifiable.
Disputed questions?
My lord, the claim and counterclaim by the managing committee, by the writ petitioner, my lord, and insofar as the state is concerned, whatever we had found in our documents or whatever has transpired in the inquiry, my lord, we have placed on record, my lord. And according to us, there is a school which is still running and which is getting the fund.
What additional thing you want to place? You have placed
No, nothing additional, my lord.
So that is your case.
That is my case, and
terminated.
Terminated and a separate school in existence.
That is okay, but then she then thereafter she never remained a part of the action.
Yeah, okay, that is it.
Para 9, my lords, of my rejoinder. We say that these are. This is filed on 22/8/2019.
22/8/2019.
My lords, rejoinder to this affidavit filed on 7/6/2019.
There are many documents this court is holding. You have helping hand. We do not have helping hand here. Your affidavit is dated?
My lords, this is dated the 22nd of August 2019.
There is one 23rd August, not 22nd August.
probably registered one day later.
It is dated, of course, but it is received by the office on 23rd.
23rd.
Anyway.
Paragraph 9, my lords. That the deponent begs to submit that there is no averment statements in the additional affidavit in respect of the MC resolution dated 15/7/2004 and resolution dated 21/2099, and both the resolutions are fake and fabricated documents. The respondents did not submit the above said resolutions before the earlier round of litigations before this honorable court and did not submit before any authority.
All right, and what else?
This is with regard to, my lords, whether there is denial of those two documents. Now, what I'm submitting before your lordships is that page 11, if your lordships kindly have a look.
Yes, anything else, Mr. Paul?
Well, it's this termination which they say cannot be a valid termination in law. It is an invalid termination in law, if at all.
Have you challenged it? Have you got it set aside?
No, my lords. Because this has been brought.
No challenges was made.
No separate challenge has been made to this, my lords, in this matter, which is pending before your lordships.
In this present, before this court, this termination is not alleged in your thing. In your writ petition, you do not say that you stood.
Because in all the 3 rounds of litigation prior to this round of litigation, my lords, this document was never brought forward.
Anyway, what else?
Well, what I'm submitting is this document was never brought forward prior to this round of litigation in the earlier 3 rounds of litigation. It is only at this stage that this has been brought.
But then thereafter you have not filed any.
No separate challenge has been filed by us. Well, this
has been brought in 2000. When was this?
19. 2019, my lords, and this, my lords, in my humble submission, would have to be read in conjunction with the subsequent affidavit filed on 27/2/20.
Yes, that you have said already.
My lords, where the same officer says that there is no valid order of termination.
Did you say the same? No.
My lords, he says that there is no formal order of termination.
No, there's something formal and valid.
No,
is there any difference between these two?
My lords, a formal order of termination would have to be valid. A valid order of termination would also have to be a formal order.
Need not be a formal order.
I'm sorry, my lords.
A valid order need not to be a formal order.
Well, for the validity, my lords, formality would have to be maintained.
To attach validity, no formality is needed, isn't it?
Well, it's for validity, a formal.
To attach validity to certain thing, you do something which must be done.
My lords, for it to be valid, there would have to be a procedure followed.
Anyway, it's okay.
Which would then make it a formal order. I would again have to go back to Nazir Hussain. Well, if something is required to be done in a certain manner, it would have to be done in that manner itself. So merely because somebody signed on it, that would not make it a valid termination order. Which is why I say, formality and validity would probably be.
In such a case, there should have been a separate challenge to that by you.
My lords,
you see,
in the course of a defense, my lords, filed before your lordships, if a certain document is brought on record.
Anyway, anything else? That is enough.
My lords, that's the sum and substance of the matter. My lords. Of course, my lords, there's those instructions my learned friend had placed was required to place. My lords, I don't know whether
that much relevant in view of the things. We will just see if it is.
My lords.
Is there just say one thing, Mr. Sengupta? Is there any shift of bank account? Change of bank account?
No.
Of the school?
According to us,
prior to 2004-5 and after that, after 2006.
According to
same account has been maintained. Yes. Okay. And we're noting that submission.
My lords. Obliged.
Item number 6.
Asharfi, they're supposed to take instructions, no?
Yes.
Shaman. Asharfi.
My lord, I'm praying if the matter can come up next week somewhere, my
What
lord.
is this matter about?
My lords, this is a matter regarding termination of service, my lords. This honorable court has passed an order to put in quietus to this entire matter because he was not paid a subsistence allowance and he was subsequently reinstated in service and he's since superannuated from the post, my lords. So your lordships had passed an order on 4/3/2024.
Oh, therefore this matter traveled to the other court.
Yes, my lord.
Well, it's the other court, the Honorable Chief Justice has passed this order on 4/3/2024, on the basis of which they were supposed to seek instructions regarding payment.
4/3/2024. What is
My
the
lord.
order?
I'll take your lordships. My lords, if your lordships have page 2, 4 lines from the bottom of that order.
Page 2, yes, okay. Yes.
Hence, 4 lines from the bottom, my lords. Hence, in order to give quietus to the matter, the court had suggested to the counsel appearing for the respondents that the employee may be paid pension and gratuity alone for the services rendered by him. It is also suggested to the counsel for the petitioner that the employee could not insist upon payment of subsistence allowance and other benefits in order to put an end to the litigation. It is stated across the bar that during pendency of the proceedings, suspension was revoked on 23/5/2003. The counsel for the respondent sought time to get instructions and report the same and so on. So basically, it was on what is the monetary component that they are willing to
It was a case of suspension only.
My lords.
Matter ended with suspension.
No, my lords.
Termination.
Termination.
It resulted in termination.
Termination.
Then
We
what
came
happened?
before your lordships on 3 separate occasions, my lords. Termination order set aside.
Termination was set.
Set aside.
Then he was reinstated.
Reinstated.
With
Again,
all
the
the-
inquiry
with
proceeded
all
from
the
them.
bequeaths and all the
Lordships.
all the consequential benefits.
My lords, because the termination itself was set aside, it was found.
So he came back with all the consequences.
It would have the effect of all consequential benefits.
And then he superannuated.
He has subsequently super.
Now what is the issue then?
My lords, because he has not been paid anything.
That termination has been
retirement-
challenged, my
retirement-
lord.
They again came back with another termination order after your lordship set it aside on 2 occasions. They came back with a third termination order. That termination came to be challenged, my lords.
So then has to be
Heard,
then
my lord.
what
It
was
has
the
to be heard.
instruction for this thing to be taken?
My lord, we are yet to receive any instruction, my lord. We could not, my lord. We are praying for some more time, my lord. For some amicable settlement.
For 2 weeks.
As a matter of fact, this matter was heard by your lordships also at length, my lords. This is that matter where, my lords, regarding the escape of prisoners from that jail.
And the warden was
that Tura jail.
Tura
Yes,
jail,
long
my
time.
lords.
Probably.
Because the order of the appellate authority itself says, my lords, that no issues, no charges have been framed against there are no specific charges
But then you
against
said that this termination was set aside.
on
isn't it?
2 earlier occasions.
Then how could he be terminated again?
Once, because your lordships had granted them liberty to proceed with the inquiry.
De novo.
My lords.
Okay.
obliged.
Adjourned for 2 weeks on the request of Mr. So-and-so learned so-and-so to enable him to obtain necessary instruction.
Item number 7.
Gulab is also for instructions only, no? My lords, in item number,
This also has come back from there.
my lords, there was a direction for the
Now
officers
what
to appear
happened?
in
All the
person.
matters has come back from that court.
My lords. My lords, the officers were directed to remain personally present through VC. I think they are here, my lords.
Yes. Now what for these officers are requested to be present here?
Again, my lords, this is a matter where they were in service and during the currency of this writ petition, my lords, the 2 of them have retired. So it is only a question of paying them the benefits, my lords. Won't it be appropriate that this matter be placed before the same court?
One is we will be entitled to regularization. We will be, if the relief is granted, Who will be entitled to monetary compensation?
Only monetary
And one
compensation.
will be entitled to regularization.
I'm sorry, Malaj.
And one is entitled to regularization.
He also may not be entitled to regularization per se, Malaj. He's still continuing against that post. But regularization, Malaj, in view of Umadevi, things may be a little difficult for us.
So it is with regard to the offer of monetary compensation.
Lordship.
That is what is to be negotiated, isn't it?
Lordship.
That is why this court wanted the officers to be present.
My lords.
Any offer came?
Nothing yet, Malaj. Nothing that I have been told.
Yes. Who is appearing? Who is there? Who is present on behalf of the office?
On behalf of the Deputy General, Deputy Accountant General is there in the.
Yes. So what is? Are you going to make any offer? Yes, Mr. Deputy Accountant General. Are you
Yes, sir.
any offer?
Yes. Lordship, here the Deputy Accountant General is here with me.
Yes. Kindly.
So what has
see,
happened? What has happened in this case is.
Mr. Kharmaflam, kindly
am I audible?
tell him to respond. See, this basically here we are confined to the offer of monetary compensation. Are you offering anything? Are you ready to offer anything?
No, sir. We are not the appointing authority. We are not the appointing authority.
Then who will be?
All the officers are appointed by the Director of Civil Defence officers only, sir.
No,
The
anyway,
appointment
let
order
the
is-
appropriate authority take a decision. You can forward the matter to the appropriate officer or appropriate authority for taking a decision in this regard.
Yes, sir.
Now, are you willing to do that?
So, Lordship, you see at the appointment letter, it is it's been issued by the Director of Civil Defence and Home Guards.
Yes.
So, Lordship, here the matter of providing compensation also does not arise. As what has happened in this case is their appointment is purely temporary, Lordship. And we were just instructed.
They have completed the service.
Yes, hold on, Mr. Khanma, from one second.
They have completed the entire service, Malaj, in that same office. During the period of their service, Malaj, they were not paid. They were only paid a certain amount, Malaj. The other benefits, as has been.
What was the basis of their appointment? They were on the regular appointees, or
They were not regular appointees, Malaj. They were.
okay, but then it means Mr. Karmaflang, you are not in a position to offer any monetary compensation, isn't it?
As of now, no, Lordship.
Then
As of now, no.
we
Because
proceed to this thing to set on merit.
Your Lordship, in this case, may I just point
Yes,
out?
yes.
Your Lordship, yesterday I had a discussion with the Deputy Accountant General, and I just take the stock of it. They are giving the salary and others. So whatsoever I got the information, Your Lordship, as per discussion, that's they have given the salary to them as per government norms of the state of Meghalaya, though they have taken at the outsourcing from the Home Guard. So there is nothing due to be paid to them.
So yes, we appreciate your submission. This court will have to go to the facts of the case.
Matter would have to be heard, Malaj.
So until unless you see, like, so we can say that there is no offer of compensation, and then matter has to proceed on merits. We can say
we can do that, Your Lordship.
yes. Okay.
Yes, sir.
Pursuant to the order dated 27/5/2024. The concerned officers have appeared before this court. Through what do you say? Video conferencing.
Video conferencing.
Through video conferencing. It is stated that none of the petitioners are entitled to paying any monetary compensation, and hence the department is not in a position to make any offer
compensation. Stop. In view of the statement, it appears that matter will have to be heard and decided on its merit. Then when shall we have it for hearing?
After 2 weeks.
Just say on the request of the learned counsel for the parties, list this matter for 2 weeks. It is already in the hearing column, isn't it?
That's all.
It's in the hearing. Lordship has heard it also.
Highly obliged, Your Lordship.
But again that it was.
It was heard by my lords, then it went up.
Went up to Chief Justice Court, again came back.
Item number 8.
Obliged, Your Lordship.
Yes.
Well, as I pray for a little accommodation, I have not
But
been.
today the whole day is for you, Mr. Paul.
Seems like every time I want to turn back, my lord, somebody comes and says.
Who's the other side? Yes. When you'd like
After
to...
a week, my lord.
Okay, at the request of the petitioner, list of priority.
Obliged.
Item number 11.
May it please your lordships.
Yes.
Lordship, this is that matter I had mistaken.
Okay, you had not even bothered to go through what under what.
My lord,
provision
in
of
the while drafting the memo
Yes.
of appeal, in the facts I have checked, I have categorically mentioned that he has been convicted under Part 2 of Section 308.
See, there
But
are
at the
two
time,
places you have mentioned. See your cause title. You say one thing. See the body.
Lordship, cause title is according to what the judgment by the accused appellant. Yes, Lordship. One please.
See, this court has gone
Yes,
through
Lordship.
it
Yes, Lordship.
before reordering
Yes,
the
Lordship.
listing of the matter.
Lordship.
Because something has to come from your mouth. You see,
Yes,
like it should not court should
No,
not pass
Lordship.
judgment without even letting know the counsel.
That my error.
Anything you want to say more? Any more thing you want to say?
Lordship, my only one humble submission, Lordship. My prayer remains the same, that the sentence period may be set off
Provocation. Nikki provocation.
till today.
Done.
And the only thing is, since the learned trial court has also appreciated that the appellant herein did not have the intention to hurt the victim, but it happened in a spur of moment. That is there at, if I may just take your lordships to paragraph 22, page 137.
Page 137.
Yes, Lordship.
Yes.
If I may read paragraph 22.
Yes.
Though above narration of the case at their hand is a different fact and incidence, but this court has relied on the above authority only for the guidance of presumption of innocence, for it is the duty of the court to presume innocence unless the accused is proven guilty of the act. In the facts of this case and evidences on record, the prosecution has not been able to prove the case against the accused as an act liable under Section 307 IPC. In this instant case, actually from the weapon used is found to be an act with intention, but this court, taking cue from Section 313 subsection 4 CRPC, also cannot simply ignore the fact that accused has no mens rea nor guilty feeling, as it was an act in spur of the moment when the victim and his friends approached him at PO on their own, asking him questions in intimidating tone, and for a young lad like the accused herein being intimidated by the similar aged persons like victim and his two friends PW2 and 3, will be in all human probability that accused will act for self-defense. And since the victim who climbed the driver's door asking the accused as to why he acted smart when he does not know driving, which fact was found in evidence of victim PW4 himself at para 5, which evidence shows the preponderance of probability that accused was provoked by the victim PW4, who asked the accused as to why he drove the truck again and again. Now, taking this particular fact into consideration, the learned trial court has altered the charge from Section 307 to 308 Part 2. Now, my lord,
Yes, court has convicted you under 308
Yes, Lordship.
without altering charge.
Lordship. So, conviction under 308 part 2, the maximum punishment that can be awarded is 7 years, Lordship. So, in my humble submission, since the learned trial court has held that intention was not there, it was in a spur of moment. So, my only prayer is that he has already undergone almost 6.5 years of sentence.
No mens rea,
No mens
only
rea is
actus-
there.
actus reus.
Only actus reus is there, Lordship. So, on that ground, my humble prayer is that the rest of the period
sentence can be reduced and then
Lordship.
he can be.
Lordship.
Okay.
Deeply obliged.
Anything, any resistance
no.
to our submission?
No, my lord. I have already made my submissions.
Yes.
Deeply obliged.
This is also reserved.
Obliged, Lordship.
Item number 13. Item number 14.
May I please, Your Lordship?
Yes.
Petitioner counsel, it seems.
May I please, Your Lordship, this item number 14 and 15 is a connected matter. And another matter, CRL petition 13/2024.
Not listed
is,
today.
No, Your Lordship.
Yes.
It was listed on 19/6, so let it be tagged together, Your Lordship.
Why? Why should we tag together?
Be tagged together.
What is the connection between those
under-
matters and this?
For that, I have no instruction, Your Lordship.
Then
but-
why we do not tag together just on the request made?
It does not need to be tagged, Your Honor.
Yes.
Does not need to be. Does not need to be tagged, Your Lordship.
Petitioner's name in
So
that
there is no
case,
requirement of tagging it together.
Petitioner's name in that case is
It's a different
Bora
person altogether.
What is the case about?
Lordship, these disputes are absolutely this item number 14 and 15. Basically, what had happened is in both the cases, they are challenging 2 FIRs in each case. It is only the accused person who are different. Both the accused person in the petitioners in item number 14 and 15, they are officers of GHADC. One person is the lot mandal and the second one is an officer.
Petitioners.
Yes.
They are government servants.
They are government servants, Lordship. Now, they are GHADC officials. So, one of the private persons had lodged an FIR stating that a land belonging to a third person has been mutated in the name of somebody else. It belonged to one Mr. Gupta and it has been mutated in the name of somebody else.
Jane.
The basis of the private respondent had to file this particular FIR. Subsequently, when
Who
the
is for the
search,
petitioner?
Mr.
You are the
S. Day, I am the state.
Then where is the petitioner?
Mr. S. Day is appearing for the state.
Where is he?
He's having some personal difficulty, right, Lordship?
In fact, Lordship, this matter, these 2 matters, in fact, they have been adjourned, my lord. It got listed for hearing for the first time on 6 November. From November till today, either the petitioner or the respondent number 2, on every occasion they have prayed for time without any intimation. In the beginning, once or twice I came physically also, just for one matter. But now, my lord, they don't inform, so when only this case is there, I don't take the risk of coming all the way, my lord. They never inform. It has always been adjourned. And the second FIR which has been challenged, my lord, it is not by a private person who has filed the FIR. The police officers have suo moto registered an
What
FIR.
do we do in the absence of the petitioner? What is the problem? What do we do?
Watch.
Yet Mr. Paske.
Yes, Your Lordship.
This will go to some other day.
In fact, Lordship, in item 15, a stay has also been granted with regard to the first FIR, saying that it is basically due to a civil dispute. But because of the stay with regard to that FIR, the suo moto FIR which has been registered, the investigation of that case is also not getting proceeded since November.
What? Stay of investigation?
Yes, Lordship.
That has been stayed.
Yes, Lordship. In item number 15. In item number 14, there is no
What is
stay.
the order? Item number 15 just.
Item 15, my lord, the conducting counsel is Madam T. Yangi. So,
Let us see what is the order. You say that it is order has been changed. Order of stay. By which order this has been stayed?
Lordship, I
Your,
don't
your,
remember
your
the
Lordship,
date.
even in item number 15, the stay is there of the investigation has been
It's
laid.
only in
By
item
order
15.
9/8/2023.
9/8.
Your Lordship.
Wait. No, that is because see,
It was
AG has considered that is a civil
Yes,
matter.
Lordship. But because of that stay, the second FIR investigation is also not going on.
It's all right. See, your submission has been recorded. Now, how we can refute your own submission? After 2 weeks, on the request of the petitioner.
DP obliged, Your Lordship.
14, 15 both.
Item number 17. Second call, item number 2.
Today this matter also be taken up next week sometime.
When?
Next week sometime.
After a week, on the request made by the parties. List after a week. Huh? Nothing more.